Yes.
Turn system on.
Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within, and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Officer Spady. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Tan, and to my left is Judge Wood. We'll be the panel for the remaining 5 cases on our docket this morning. I suspect that we'll hear 2 cases and then take a brief morning recess and come back and hear the remaining 3 matters on our docket. See some familiar faces, but for those who are not familiar with the appeals court, it's 15 minutes per side. There is no rebuttal. We've read your materials and are familiar with the case law associated with your matters, so you need not review those things with us, but of course, how you use your 15 minutes is up to you. We've heard the first matter on our docket. The next matter on our docket is docket number 25P0589, Commonwealth versus Scott Fontaine.
Thank you. Good morning. May it please the court. Stephen Nato on behalf of the Commonwealth. First, I would like to apologize for some confusion about the exhibits. I couldn't tell from the docket whether they had made it from the trial court. It seems like they have. That's good.
They have indeed. We had an opportunity to review them. Thank you.
We are asking the court today to find that the trial judge erred in granting relief under 25B2. Our position is the evidence was sufficient to sustain the convictions without reference to the struck evidence, but also we believe in the sort of unique circumstances of this case that we should be entitled to full consideration of all the evidence that was presented during the Commonwealth's case in chief. We are also asking the court to find, if obviously you agree with us as to the sufficiency issue, that the judge further erred by ordering a new trial under Rule 30. And again, in reference to Christie, even if the evidence was appropriately struck or not there for the jurors' consideration, under Commonwealth versus Christie, they could follow that instruction and return proper verdicts. But if the judge was wrong in his ruling striking the evidence, the defendant suffered no prejudice. So even if the limiting instruction was insufficient, the defendant could not have been prejudiced by the evidence that he struck. I'll begin with the sufficiency issue without reference to the struck material, beginning with the indecent assault and battery. The image particularly reflected in Exhibit 16 shows the defendant pulling his daughter's underwear off to the side, exposing her buttocks. I think just the appearance of this is not a family photo of a day at the beach, and it has no artistic value as articulated under Sullivan versus Dunn. I think the jury could look at this image, find that it is unusual, listen to the wife's testimony that this was not a normal photo, or these photos were not normal photos compared to the usual family photos they took, and see that this appeared to be an indecent act that was depicted for them. And that being the case, I would suggest that it satisfied the elements for child pornography as well.
So we don't know what actually is happening in the photo, correct? Do we know if that photo stood alone, or was there a series of photos at the same time?
Yeah, I don't believe the timing was not set out, whether it was all one act, but was that the question?
Yes, with respect to what, first of all, has it been shown that that was indeed Mr. Fontaine's finger?
Yes, I believe there was no real dispute as to that, and certainly under the sufficiency standard, it was taken from his phone. He kind of made that was not in dispute, and his wife testified that she believed it was his hand, and I think the circumstances would warrant that inference. And she recognized the underwear. It was consistent with underwear that was found by the police when they executed the warrant. The comforter was recognized, and so they could see that indeed it was this defendant pulling the underwear aside. And that ought to be, I think, sufficient for indecent, and the depiction of an indecent assault and battery in these circumstances with the exposed buttocks would be child pornography within the meaning of the statute.
So I'm sorry, you said that should be enough for the child pornography? Or?
Yes, under the dosed factors, and in part because if we accept the predicate that it depicts, what it depicts is an indecent assault and battery, where there is nudity involved, obviously indecent would presuppose that these sexual overtones.
Wait, sorry, you're confusing me analytically because you seem to be relying on the fact that, in your opinion, the photograph. The question we're dealing with right now is whether this is child pornography, possession of child pornography. And in order to establish it as child pornography, you're saying it depicts an indecent assault and battery, which we're also trying to determine.
Yes.
Okay, so that confuses me. Separate, because that's a question in dispute. So you can't assume for the sake, well, maybe you can. Here, my analysis is this, and maybe you can help me out. In child pornography, is this objectively lewd? That's what we're supposed to decide. Is this objectively lewd based on the four corners of the photograph? And your brief was confusing about this point. Do you concede that I've stated the test correctly, that all we're supposed to look at is the four corners of the photograph?
I do not concede.
Okay, why not? Because given that, I'm going to quote now from Commonwealth v. Sullivan, the focus, I'm quoting from the appeals court, the focus is on the four corners of the photograph in measuring lewdness. How do you get around that?
I believe it's that line of cases, Sullivan, is about four corners because the defendant's state of mind as possessor of the image is irrelevant, and I agree with that. So when you're dealing with mere possession of it,
So you do agree, then, that it is on the floor?
but not here where I think the evidence shows that the defendant created that image. So his state of mind as the creator becomes relevant. And I was point to the sixth dosed factor, which asks whether the image was intended to elicit a sexual response. And so that sort of inherently involves some question about what are the circumstances where this was made. Those federal circuit courts that I listed in the brief have acknowledged a limited context test where the circumstances of creation are maybe relevant to consideration. And the First Circuit did say that, in fact, it's a misreading to impose a four corners.
So to be clear, it's your position that that picture, standing alone, if somebody were to view that picture, that's child pornography?
Yes. Yes, and I realize that may be a difficult argument to make on these circumstances, but here I think under the Lattimore standard, given what is depicted, and again, still without any reference to the struck evidence, assuming if the jury could in fact look at this image and see a indecent, inherently sexual act being committed on a child by the defendant, exposing her buttocks, and which is specifically identified in the statute, the jury, same jury looking at this, seeing an indecent assault and battery, could say this is also, therefore, child pornography.
Okay, so the consequence under our case law that, let's assume, for the sake of argument, that I don't agree with you about anything other than the four corner. We have to look at this objectively. I assume I follow appeals court precedent, which is we are looking at the four corners of the document for lewdness judged objectively. That's the test I'm trying to apply because we've applied it before, and I like precedent. So the consequence of your argument is that if anybody any parent anywhere had this photograph, they would be guilty of possession of child pornography. Do you agree that that's the consequence of your argument?
If it's four corners, I think we would be left.
Right. And your argument about creation being relevant as under the sixth dose factor, you're relying exclusively on non-binding federal precedent.
Yes.
Right. Okay. So you admit that you're making an argument that's extending beyond our precedent and built on non-precedential federal.
Yes, although I don't know necessarily this exact question has come up in those cases, generally in Sullivan, for instance.
So you're analogizing to non-binding
Yes.
federal appellate precedent.
Yep.
Okay.
But I'm also not aware of anything specifically saying that the circumstances of creation in Massachusetts is necessarily always irrelevant. But that does seem, I acknowledge that does seem to be the general thrust, not having.
Wait, so that sounded like the opposite. It sounded to me, you just said that the factor of creation, in other words, we all agree that the defendant created this photograph. So the question is, I think, for us, and the argument you're putting to us is, does the fact that the defendant created this, where the charge is possession, add anything? And I think you just said there's no case law in Massachusetts that it's irrelevant. But I think the question is there any case law in Massachusetts that it's relevant?
Well, I apologize. What I meant to say was that in the circumstances here where the defendant's alleged to have been the creator, that those external factors are relevant or irrelevant. I'm not sure of it.
There's no case law either way in Massachusetts.
But certainly, I think under Sullivan, for instance, it's very clear that merely when the defendant is alleged to be the possessor of that image, there can be no external circumstances that come into it. In that case, it would be the four corners here.
Right.
And I apologize if
that's okay.
That was not clear.
Complicated.
I think you answered Judge Wood's question directly, but just to be clear, you said that any parents who would have possessed that photograph would be guilty of child pornography. Is that your answer? Yes?
With this image, I would say yes. I think it is clearly a disturbing image on its own, clearly when given context.
Disturbing is not the standard.
Right. So then you're saying that if someone and, parents who have children might, I think, be able to relate to this, saw a rash on their child's bottom, right? And wanted to take a picture to show the doctor and pulled their underpants back and took a picture.
Yes, but here, of course, there's no rash, and then...
Well, but you understand the
Yes. And then at that point, I acknowledge I do have to look to rely on the sixth dose factor, which is, what was the image intended to do? And those factors have been adopted. So I think, again, leaning very heavily on that factor, that what was it intended? Clearly, the circumstances here was not intended for, and I think it would be that factor which would carry out the normal parental concern type photograph, or normal parental, like family day at the beach, child in a bathtub. But that's not what we have.
A number of pictures were admitted.
Sorry?
A number of pictures.
Yes.
And several of the pictures are just of the child, right?
Correct.
So this is one in a series of pictures.
Yes. And some of those, again, to sort of establish identity of the child, some of the clothes that were worn.
Well, you say establish identity of the child. He knows who his child is, right?
Sorry?
You say establish identity of the child. This is the father taking pictures of his child.
Yes,
So
exactly.
he knows who she is.
Yes. But again, going to the earlier question about how can we be sure it's his finger pulling off of this?
So can we get to your argument about the statements and why you think that the judge was wrong in excluding and finding?
Yes. So it's clear that the judge believed that these statements could only be relevant as to these two charges, as far as his possession of the image and his intent to touch the child, but not relevant at all to indecency or to the lewdness of the exhibition here. And I would suggest that the judge was patently incorrect in finding that, certainly as to indecent assault and battery, that the statements could not be relevant to the indecency finding, or that state of mind itself was irrelevant to questions of intent to commit an indecent assault and battery.
So the test, we have to, it seems to me, that we have to begin with the test for indecency. Again, we keep jumping back and forth, but let's go with indecency. Indecent assault and battery. The test is objective. And so his state of mind, how is his state of mind relevant to whether there's objectively viewed the touching has sexual overtones, which I think is the key question.
Yes, so in some of those cases that I cited, Castillo, Mioza, for instance, there are statements that kind of occur closer to the act, but have sexual overtones, secretive statements by the defendant. That can bear on the indecency. I also point to Commonwealth versus Wallace.
And Vera, right?
Sorry?
And Vera, Commonwealth versus Vera as well.
Yes.
So, but are those cases distinguishable from the facts here in that in those cases, I believe the defendants had made statements, or his defense was that it was an accident, right? Here, there's no, the defendant actually is quite silent, doesn't say anything about whether.
Well, Vera is a case where there were some searches for young girl pornography that
Right.
did bear on his state of mind that the touching intent to commit rape and indecent assault and battery. And Wallace,
He had made statements in Vera, though, that he had accidentally exposed himself, right?
yes,
I think, yeah.
And that's why the court found that the evidence was relevant, because he was raising accident. It was relevant to, his prior statements were relevant to whether this was an accident.
Well, under Wallace, they also said that some state of mind evidence could be relevant to show predatory motive, sexual intent, and lack of accident. But I think under those kind of two prongs, Castillo, Rosa, Fleury, Earhart, et cetera, show that state of mind can be relevant to the indecency question itself, but that separately state of mind, intent under Vera and Wallace are still relevant, even though the issue is whether the touching was indecent.
Okay, and I think that Judge McGuire maybe agreed with you to some extent on three of the four categories of statements to the undercover police officer. But he said, accepting that this is relevant, although I don't know that he linked it to any of this, it doesn't really matter. He said that you have a separate 403 problem. It's more prejudicial than probative. What's your answer to that?
Well, as I read it, he clearly thought it was relevant to, I would suggest, the intent to touch and possession.
Yeah, right. Right.
But because they were not relevant to the indecency or lewdness prongs under each charge, he said the possession or touching itself are not really in dispute. And so the prejudice as to these other elements is too great, so I'm excluding it. But I would suggest that the case law, again, I think clearly as to the indecent charge shows that he was incorrect, that evidence is still relevant to indecency and to his state of mind to commit specifically an indecent assault and battery, as distinguished from perhaps more innocent normal parental conduct. And I see I'm over. Again, I know an unusual case, and again, we're just asking for finding of sufficiency and a reversal of the new trial order.
Thank you. Attorney Blythe?
Thank you. May it please the court, good morning. My name is Catherine Blythe. I represent the appellee defendant in the trial court, Scott Fontaine. I'd like to start with a couple of issues that my brother pointed out. But the first thing I want to address is, as to the child porn sufficiency argument, I disagree with my brother. There's no Lattimore standard that needs to be applied there. I think the law is clear that it's a de novo review by this court as to the four corners of that depiction. And I agree with some of the questions asked of ADA NATO about whether or not the test is limited to the four corners. I think that the jurisprudence in Massachusetts is very clear that it is a four corners analysis, that the subjective intent of a possessor certainly is not a relevant portion of that analysis. And I would say that it would fly in the face of the reasonings of those cases to now take into account the subjective intent of the person that creates it as well. Concerning...
The picture alone is sexually suggestive.
I do not, no. And I think that what Justice Tan pointed out, and I think you all pointed out, which is parents often have pictures of their children's exposed buttocks on their phone for a variety of reasons. And one thing that I would point out is it was stated, well, there's no rash in that photo. And importantly is we don't have the context of that photo. It's the Commonwealth's burden in the trial court level. Certainly to the extent that this was a photo that was unlike other photos, the Commonwealth had the ability to show that by introducing further exhibits and by asking, quite frankly, their witness, which was the defendant's wife, as to whether or not anything was occurring at that time could have explained the showing of that buttocks. But the absence of a rash could have been just as easily taken in order to show that a rash had cleared in order to show a doctor. And I think that we would all agree as parents that I should be able to take that photo and pull away my child's underwear in order to send it to a pediatrician, for example. We don't have any proof of any other lewd or lascivious conduct in relation to that photo or what was found on the defendant's phone in relation to that photo. So I'd suggest by the four corners analysis that the Commonwealth failed and that under de novo review, the court should find that they do not meet the standard of child pornography.
What about the indecent assault and battery? Can you talk about the sufficiency of evidence?
Sure, and I think that's a closer call for the defendant in this case under Judge McGuire's decision. I think there's certainly case law that supports the fact that the removal of clothing could fall into an indecent assault and battery, and that becomes clear. And so the question is, under that objective test of indecency, was there enough in this case? And I would suggest that there's not. I would suggest that, again, there are a litany of reasons that parents may pull away clothing from their children, that does not by and of itself make a touching indecent. I would suggest that Judge McGuire's ruling on the sufficiency is spot on for all of the reasons that he stated in his written decision.
Well, so if we agree that the crucial central question is whether it had sexual overtones, and we're at RFNG, required finding not guilty stage, and could any rational jury have concluded that this photograph, which we viewed, had sexual overtones? You know, understanding that as an appellate judge or a trial judge, I might personally think no, but is a juror reasonably capable of that? That's the test, right?
Yes, that
right.
is the test,
and
yes.
So what's your argument on that?
And so I would fall back on what I said, which is I think it's a much more difficult argument for the indecency than it certainly was for the child pornography count. But my suggestion is that the lack of evidence supporting the environment in which this photo was taken is what fatally flaws the Commonwealth's argument in terms of the indecency.
Can you address the points regarding the statements that the Commonwealth had made when it comes to, with the judge's decision?
Absolutely. So,
and also, secondly, why can we not trust that the jury could have followed the judge's instructions?
So if I could take the second question first, I think that the case law is clear that when the evidence overwhelms the jury, though we do trust juries oftentimes in order to follow it all the time, to follow a judge's decisions, there are times when we say that the inflammatory evidence was so overwhelming in this case that we can't trust the jury to have done that. I think that the Roe case is on point in terms of also indicating that when a curative instruction comes too far after the inflammatory evidence is introduced, that becomes problematic for that analysis as well. So I think the Roe case is on point. As I noted in my brief, it is the bulk of the Commonwealth's evidence in this case. The longest witness by far was Detective Schatz and that inflammatory evidence. Go ahead.
Okay, so what about the previous question? Why aren't these statements probative of,
Sure. So I think as to.
or at least some of them, maybe not
Yes.
all?
So
but-
there's, the judge, Judge McGuire made it easy in separating it into the 4 categories, which I think was very helpful. I would suggest that certainly his predilection into adult homosexual behavior is absolutely irrelevant in this case, based on the case law. And I'd suggest that based on the case that I cited, that quite frankly, that's enough in and of itself, and the courts have held, for a motion for new trial to be allowed.
What about the statements, though, that he played with young girls' panties and also that he was sexually attracted to young girls?
I think that the judge's 404B analysis is spot on in this case. I think you're talking about prior bad acts, really, of the defendant that are being admitted in order to prove propensity in this case. I would suggest that I'm not proclaiming, and I will tell the court, that it's not that these statements are irrelevant, right? So it's not that they don't tend to prove anything. I think that that would be a failed argument for me to try and make. But when you're discussing whether or not the prejudicial component, inflammatory aspect
Your
of
weighing
these,
just goes the other way than the Commonwealth's, right?
that's correct. So, and I think that especially in this case, where the defendant, there really isn't an issue with accidental touching, whether or not it's the defendant that was doing the touching. So we're not in a situation like in some of the other cases cited where we have those questions at hand, where the defendant has made a statement and has called into question whether or not, or what was his intent when he touched, or whether or not that touching might have been accidental. That's not a question that was before the jury, and it certainly brings down the probative value of that evidence. And in bringing that down, the inflammatory nature of that evidence in the scales certainly tend to tip in the defendant's favor, in my opinion.
And the standard of review, this is an evidentiary question. What is the standard of review?
I would say that it's an abuse of discretion from the court, and so it would have to be a clear error of law, and I would suggest to the court that's a well-thought-out decision in which he takes the appropriate analysis step by step, and I would suggest that there's no evidence of a clear abuse of discretion in this
Right,
case.
and can we, I want to just pause and drill down on that for a second. I mean, I make sure that I'm understanding it, appreciating it. It's an evidentiary question, and the judge has heard all of the evidence at trial, and it's a weighing question as well. So he's saying, acknowledging the relevance, but he's also got to consider the the prejudicial effect, and he's seeing all of this in real time in front of jurors, from the witnesses, and it seems to me that a lot of that is subjective, and that's one of those areas where it makes complete sense why we give discretion to judges and to make these sorts of judgment calls, evidentiary questions happening in real time. Is that all fair, do you think?
I do, and I think that special deference that is given to judges in evidentiary rulings is especially important in this case because Judge McGuire was sitting through the bulk of the entirety of the trial. He's watching jurors' expressions, he's watching witnesses' expressions, and those things matter when you're making these judgment calls, which is exactly what we charged him to do, and he did it thoughtfully, he analyzed it appropriately, and in his subjective opinion, that 404B analysis weighed in favor of excluding that evidence.
Oh, wait, sorry, you just said 404B. That could be, but it's also 403.
That's
right.
correct.
Okay.
Yes.
Okay.
I would also like to talk about just briefly the excluded evidence and whether or not for the charges for which the Lattimore standard applies, indecent assault and battery, whether or not that excluded evidence can be considered in the sufficiency finding. And I would suggest that nothing in the case law suggests that it can be. So certainly the case law suggests that we can look at erroneously admitted evidence, which is evidence that was objected to. Perhaps the judge made a wrong judgment call, but it's in evidence before the jury. But that's not the case here. At some point in time during the course of the trial, the judge excluded the evidence, struck it from the record. And that no longer becomes a fact of the case that the jury can consider in deliberations, and therefore is not a fact of the case that should be considered under that Lattimore standard. And so I would suggest to the court that when we're looking at the sufficiency, it's important that we not look at any stricken evidence because they are not facts of the case. I'd suggest that the cases cited by the Commonwealth about erroneously admitted, it's actually jury instructions in those cases. In Buttimer is a jury instruction in which the judge misstated the law to the jury, to the defendant's benefit, and then the defendant brings it up in an appeal and was not very successful, understandably. But I would suggest that we're not talking about erroneously admitted law. We're talking about facts that were stricken from the record, which are no longer even considered a fact of the case. And so I would say that that's where we can differentiate Hennessy and Buttimer in this case from what we're talking about when we're talking about excluded evidence and the sufficiency findings. In terms of circling back to the child pornography, where Rex is so clear that the context of possession is irrelevant, I don't think there's anything from even the dicta within that case that would allow you to suddenly put emphasis on the context of the creation when we don't. I mean, if you think about logically what we're trying to do with child pornography and the possession of that, even when a person may have sexual predilections, we say that that's not relevant to whether or not this is possession of a child pornography. And so the same goes for the creation, because otherwise we're going to be starting to ask the circumstances under which pictures are taken and open up and confound, I think, First Amendment principles. So I would suggest that the Commonwealth's argument as to that falls flat as well. It wasn't addressed, but just briefly, the 25B2 analysis done by the judge, I think that very clearly, Judge McGuire does a great job in his footnote explaining the power that's been given to the judges under Woodward's progeny. And so if there's any question about whether or not the judge abused his authority and essentially opening up following the return of verdicts, opening up the question of a motion for new trial, and then ultimately going beyond that motion for new trial, and he really entered himself verdicts of not guilty without any party seeking that. I would say that the 25B2 and Woodward and its case laws suggest that that's exactly what Judge McGuire should have done. It's clear that what 25B2 is attempting to do is make sure that justice is served, and in doing so, making sure that what goes to a jury and a conviction stands on legal footing, and that in his view, having looked at the case, looking at all of the relevant case law, he felt that justice had not been done, no crime had been committed, and I would say that under Woodward and 25B2, that's an appropriate analysis for him to take at that point in time.
Remind me, at that moment where he had the light bulb and thought this was a live issue, did he invite argument from both sides before acting?
He did, and so it's kind of an interesting how this all came about, which is that trial counsel had failed to object to the introduction of these text messages outside of a suppression motion. In Judge McGuire's mind, when they were being brought in, I think pretty clear from his decision, was the lewd and lascivious aspect of a charge which he later directed out because it did not fit within the statute. That issue had not been brought before the court by any counsel prior to the directed verdict, which from my reading the transcript was a pretty run-of-the-mill directed verdict argument. In other words, it was not argued specifically by either counsel that it did or did not fit into that statute. Judge McGuire specifically asked about the issue. Both parties were given times to brief that issue, and then was brought back before the court as to whether or not that lewd and lascivious count should have been, it should even go to the jury, for which he directed out at that time. And that kind of opened the can of worms for this entire issue, which is whether or not the messages should have been allowed in. And I think that, frankly, according to his analysis, had that count not been proceeded by way of trial because of the statutory limitation as to the nudity aspect on lewd and lascivious, these messages would have never been brought before the jury. And so I think circling back to Justice Tan's question, which is why can't we just try and trust the jury to go forward and follow the judge's instructions? Well, I mean, really, we shouldn't have had to trust the jury to do that in the first place, because the Commonwealth had no basis to go forward on that lewd and lascivious charge. And the only relevance to those text messages at that time was because of a charge that ended up being directed out on basically statutory grounds of it not fitting a definition. And so unringing that bell became very difficult to do, and it wasn't done until the next day. And so that's kind of also the delay in the time on the curative instruction, was also because this issue wasn't brought up before the court when the messages were introduced. For all of those reasons, I see my time is running up. Unless there's any other questions, I ask that you uphold the judge's decision, find that there was insufficient evidence as to both counts, and if there was sufficient evidence, allow the motion for new trial to stand. Thank you.
Thank you. The matter stands submitted. Next on our docket is 25P0964, Commonwealth versus LOVANT E. Wheeler.
Thank you very much. Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. With me today at council table is Michael Tomasini, who's the trial prosecutor in this case. The motion judge found here that the search everything statement, which I'm going to say out loud, even though we all know what it is, just to be absolutely specific, you can pop, let me look, I'm a pop everything. You can search.
Yeah, but
everything.
before that, other stuff happened, right? And I'm interested in that other stuff that happened before that because it seems to me really important, and also your opponent says it's really important.
Of course.
Right, so before he says, I'm going to pop the trunk, you can see everything, he's stopped for a traffic infraction on a dark street, and 3 armed guys come at him, right?
Well, I think that's an overly aggressive way to state it. They approached
3
him.
armed guys come towards him. What part
absolutely
of that
did.
is inaccurate?
No, that's not inaccurate.
Okay, and then one of those 3 guys steps between him and his car,
Right.
right? So you've argued with your opponent about whether he's surrounded at that point. Are you maintaining that he's not surrounded?
Yes, there's no one behind him. I mean, he has
Okay, so
officers-
there's 3, right, there's one. there's
I'm
some-
just technically using the word surround. He does have an avenue of egress, but I
No,
admit
but
that there were
there's
3
several
officers.
police officers. They're around, one is here, and then the Burke is in front of him, right? So they're,
There's one on his right, his left, and in front of him, but behind him, there's no one.
They certainly crowd him.
Pardon me?
They certainly crowd him, right?
Prowling?
Crowd.
Crowd. He's crowded.
Yes, yes, it's a narrow space, and the officers do have concerns because he got out of the car.
Right, no, but,
because-
okay, but so,
Right.
actually, I'm going to go back and, I mean, he has a path of egress. I think the door might actually be behind him, but I'll give you that. Let's say that he could flee. Let's say that's possible.
Okay.
Okay, the next thing that happens, which is really important, is that before I'm going to pop the trunk, you can see everything, is that one of the officers grabs his arm, we're not arguing about this because it's on the video,
Right.
and pulls his arm away from his head. That happens, right? Before he says anything.
Pulls him away from the car. His hand is on him for 4 seconds, yes.
Okay, so he's seized at that point.
Well, yes, but that doesn't matter because he's not. Any
Is the
seizure that
seizure,
occurs-
okay, well, let's say,
Is the
I guess
sa-
we decide whether it matters.
Yes,
But-
yes, of
But
course.
here's the question that I have. Is that seizure illegal?
No, I think it's
Why not?
because of officer safety, because he's going into the car because he wants.
Well, wait a
to
minute,
go
but you conceded in your brief
But you-
that there was no, that the pat frisk
pat
was
frisk is-
illegal.
Right, the pat frisk itself said was legal, but even if the holding onto him were illegal, I don't think it matters because there's no exertion of authority at all on the car. Anything that they
Well, okay,
asserted-
pause for a second. You're saying, I didn't understand that.
glad
It's even if the seizure, meaning the grabbing of his arm by one of the 3 officers, is illegal. Okay, so conceding that's what it sounds like, conceding that that's illegal, it doesn't matter. That's an illegal seizure. That seems like it matters.
Well, but the question is whether or not his statement of consent was freely and voluntarily made. That is, was it the product of coercion? Was it no more than the mere acquiescence to a claim of lawful authority?
Right, and
That's
is
the
a
question.
seizure, thank you. That's exactly what I was going to ask.
Yes.
Right, so it seems to me that if he's the subject of an illegal seizure, then you've got a really hard road to walk here to
I understand that.
establish that it's not mere acquiescence to a claim of lawful authority. And by the way, there's a second arguable seizure that we haven't even gotten to before he makes that statement. I can't remember, the guy who ultimately, the officer who ultimately does the search, is got 2 hands out, and again, we're not arguing about this because it's on the video, and maybe brushes his arm, but is clearly about to do a pat frisk, which
Has
is,
not-
I think you've conceded, unjustified.
The pat frisk that happened after, he had not started the pat frisk.
Right, but he was about to.
Yeah, but
he's
right,
about
he
to.
wa-
He's
right.
got his arms around his belly, basically, right? Both hands around his
They
belly.
are very close to the pouch on his pocket. But
Right,
he
so
has
it's
not-
clear to everybody he's about to be pat frisked
Right.
by the second officer, already being held by the first officer, right?
Right.
None of that's
No,
inaccurate,
I'm
right?
sorry. The holding is over by that point. It's 4 seconds of holding, and he's no longer. The
Oh,
The other officer is not holding him when he goes, because his mere purpose was to move him away from the car. 4 seconds.
all right.
So,
Okay.
one at a time.
Okay.
But as I said, and I'm going to focus on this, if court disagrees, then it says there's no claim, no exercise of authority to search the car. No one's talking about the car. No one's even brought it up until the defendant volunteers, you can search the car. And I think it's very important that we're not talking about something that was taken from his person after this. All the cases, I've not seen this in any case where the thing that is searched by consent is something other than what the police want to look at. And here, there was no request at all. They didn't say, may we search your car? He absolutely volunteered it while they were focusing on him. So even if the touching of him was not lawful, that does not necessarily mean that his volunteered statement about the car that no one was talking about was not valid consent. It was,
Okay, so there's no attenuation argument. This all happens bang, bang, bang. This all happens right away.
Oh, yeah.
Right. And so his consent to search the car, you're saying, which happens immediately after the 1 or 2 seizures, which I think you've agreed are illegal, while he's surrounded by 3 officers, is not, it can be something other than, is not a mere acquiescence to a claim of lawful authority, because the thing he's consenting to is not the search of his person, but the search of the car. That's what you're saying?
that is what I'm saying, that
And I have to accept that for you to win? In other words, there's no other argument. That's the argument.
You know, that is the argument.
Okay.
Yeah,
I
have
haven't
to show-
misconstrued the argument, have I?
No.
Okay.
You're not. I have to show that when he consented, that it was free and voluntary at the time that it was given.
Consent to search the car.
Consent to search the car. Was it valid when he made the search everything statement? And I said that it was because the frisk had not started, though I have to admit that it was about to commence. It was pretty obvious it was about
And
to
there had been a previous, I guess, seizure
Yeah.
by grabbing of the arm.
Yes.
Which is, I mean, you
It's not
whistle right in your
insignificant.
brief, it seems, you whistle past that previous seizure. But to me, that seems important. I mean, and objectively important, that he's been grabbed by the arm by another officer. I mean, why do you think, do you have an argument that that's not important, that that's irrelevant?
It is nothing to do with the car.
Okay.
That is my argument, and
Okay.
either the court buys it or it doesn't.
Thank
When
you.
we're talking
Thank you.
about consent, we're not talking about search of his person, we're talking to search the car. That is the nub of my argument, and I would agree that if items have been taken from his person, then that's a much more difficult argument for me to make. I don't even know if I would make that argument, but that's not what we're talking about. No one's talking about the car. They haven't said anything about the car, about searching it, and there's no reason why they would. And the officers even say, dude, we were just pulling you over. We're not, our intent is not to.
Well, if they're just pulling him over, then why are 3 officers coming up to him?
Because he got out of the car.
Oh.
And they were very concerned, and the officer, and I think it was reasonable, the officer testified, Officer Burke, that in his experience, it was incredibly rare for somebody to get out of his car at a traffic stop like this.
So does that alone bring the car into play? You keep saying that nothing has to do with the car, yet it seems the reason that they get between him and the car door when they first approach him is to separate him from the car. Do you concede that or not?
Yes, but it doesn't have anything to do with the validity of the consent that he makes to search the car.
But
All
why
of
are
these
they-
events
hold
are
on,
connected.
Why are they separating him from the car?
Well, because the officer testified that he was afraid that he might go inside and get something, and get a weapon or something.
So
And they don't want him to get back in his
So there was
car.
some concern for officer safety? Is that what I hear you saying?
Yes, that's why he testified, and it may not justify what, his search, but he testified that that was his subjective view, that if a guy gets out of the car and is acting animatedly and arguably agitatedly, that you don't want to let him get back into the car, because he got out of the car for a reason, so their concerns are heightened. I really think it boils down to this.
But the officers keep saying, they do say, okay, why are you getting out of the car? They make that statement. But beyond that, they keep saying, listen, this is nothing more than a traffic stop. This is nothing more than you ran the stop sign.
Yes.
Right? But the conduct doesn't seem to be consistent with that.
In the context of the encounter, what they are saying is, and I think it's a reasonable interpretation, When we pulled you over, we had no intention to search anything. We're not here to search. That's not why we're here. But then you got out of the car, and by getting out of the car, as the trial ADA said at the hearing, that put the encounter into a whole different light because
So by getting out of the car, we now want to search? Is that what initially, we had no search on our mind.
Right,
But now
and
you've
plus-
gotten out of the car, and so now,
But plus,
Now
we
what?
have his agitated action. We have the knowledge of the officer that he had been convicted 10 years ago of a
10 years
firearm
ago, did
offense.
Mr. Wheeler live in this neighborhood?
Pardon me?
Did Mr. Wheeler live in this neighborhood? Did he live in the
Yes, he
neighborhood?
did. Yes, he did. He was a resident of that neighborhood. That's in the
So that might be reason
record.
to be frustrated and animated, right? Getting stopped in your own neighborhood?
Sure, that's a reason, but there are plenty of other reasons that an officer could ascribe to it. He doesn't have to say, oh, well, I have to conclude because he's animated that the sole reason for his animation is that he's being pulled over near his house. The officer doesn't know. Although he does know that he lives in the area and he's seen him around the area many times and has had encounters with him.
Is familiar with him?
Yes, he is familiar with it. So I'm saying that's why the officers did what they did. As I said, the Pratt Frisk, we don't challenge the Pratt Frisk ruling. So that all goes to that, I
Right, wait,
say.
I mean, you say you don't challenge the Pat Frisk ruling. I think you're also saying more affirmatively, and for my purposes, clearly, the Pat Frisk was illegal.
Yes, they did not have a reason to believe that he was armed and dangerous.
Right.
And did the
At
Pat,
that-
and did the Pat Frisk, okay, so sequentially, the Pat Frisk happens exactly when?
Well, immediately after the search everything statement is made, he starts, and he starts with the hip area, and then he does his body. And while he's doing his body, the defendant says again, I'm gonna pop the trunk. So
But that's
he's
not an
cooperating.
acquiescence, and it may be limited to the trunk, we'll get to that portion
Right.
next. But that alone, isn't that an acquiescence to the authority? I mean, you're already patting me down, why are you
But
patting me down? Look
It's
at my
not a-
car, I sell clothes these days, I'm not involved in any bad
It is
conduct.
not, first of all, there's been no, it's got to be no more than a mere acquiescence to a claim of lawful authority. There had been no exercise of lawful authority to search the car, and I'm sorry to sound like
Yeah,
a
but they're
broken
patting
record.
him down, though.
Right, they're patting him down.
That's lawful authority as to him, his person. I mean, he's not supposed to know the
Right.
law, is he? I mean, he's a kid
No,
on
but-
the street.
But are you
We're
saying?
not saying, oh, I'm sorry.
Are you saying, because in your exchange with Justice Wood earlier, you're saying it doesn't matter because there was nothing about the car, right? That they were just, that
There's no assertion of authority towards the
respect to
car
the
at the
car,
time
and
he made
there's
the
no
search.
case law that you're aware of that pat frisking him illegally and him acquiescing to that authority doesn't translate into consent
Right,
to.
because every case involves an officer asking or a defendant volunteering to search the place that is then searched. This case, it's not that there's no authority for a good reason. It just hasn't happened before like this. But I think this is a case in which this distinction is significant and also meaningful, if not dispositive.
Well,
I think it makes a
hold on,
huge
hold on,
difference.
Hold on, did the place that he authorized to be searched was the trunk, though, right?
No. I'm sorry. You can pop, let me look, I'm a pop everything, you can search everything.
He says
And I don't-
he's going to pop everything, right?
Yes. But the last phrase is, you can search everything. And I don't want to sound overly simplistic or facile, but this is not that case in which they searched the air filtration device of the car when they got permission to look for drugs. This is, you can search everything in the car. And he was trying to be helpful, which the SJC has said is a sign of cooperation and consent, by volunteering to assist the officer, both by getting his registration and by popping the trunk. So I don't think that the scope of the search is limited to the trunk at all. He doesn't say in his initial search statement, I'm going to pop the trunk. He says, I'm going to pop everything. That could mean the glove compartment. That could mean the center console.
And the police continue to say, we don't want to search, but that's not what we're here for. We're not here to search. Relax, calm down, we're not here to search. What, if anything, how does that factor into this discussion?
Not at all, because because the consent was valid when made. Therefore, to withdraw that consent, he has to, the defendant,
But did the police say, notwithstanding the consent, no thank you?
he never said don't search or stop searching.
Did the police say, notwithstanding the consent, no thank you? We are not here to search. We don't want to search. That's not what we're
They
here
were,
for.
as I said, they were explaining that their initial intent was not to search.
But they repeatedly say, that's not what we're here for. Calm down, right? I mean,
Right, but then
watch the video.
he's got to make, he has to engage in an act clearly inconsistent with consent and/or an unambiguous statement challenging the officer's authority. Those two phrases I want to focus the court's attention on. Clearly inconsistent and unambiguous statement challenging the officer's authority.
Right, but I want you to be able to make that argument, but this is in the, just to make sure we're clear analytically, the rubric we're under. That's assuming the consent is voluntary.
Valid at the time it's made,
Right,
yes.
so if we haven't been on the train with you to this point, none of this matters.
Right.
But we have, assuming that the consent was voluntary, go ahead.
Yes, and there were 4 things that the judge pointed to that said met this standard. The first was the defendant said that he volunteered to go and get the registration, and the judge found erroneously that that met the standard because it's not clearly inconsistent. He's cooperating. Second, the defendant offered a second time to pop the trunk. That's not clearly inconsistent. That's not an unambiguous statement challenging the officer's authority. And third, what we were just talking about, I'm sorry.
I'll tell you my favorite, though, and the one that I'd like to hear you from. Go ahead.
Because he said that he wanted to record.
Yes.
That is not an act clearly inconsistent. He's worried about his car's full of merchandise, and he's worried about it. The officers at the scene thought so.
Is he also worried about them searching his car? Because he thought that, is it a fair inference that what the officer he thought he had consented to, or what the officer said he was going to do,
Right.
was go to the glove compartment and check for the registration, get the registration and make sure that he had the registration. That's what he thought the officer was going to
That
do.
doesn't vitiate the fact that he has already consented.
Right, he's already consented to searching everything. You can
Right.
search everything.
Right, so
Right, and then when he sees the officer not searching the glove compartment, but searching everything,
Right.
he pulls out the phone.
Right. He does not say, stop searching, you can't search, don't
Right,
search.
no, he doesn't say that.
I'm focusing on this court's language and the SJC's language. No, I guess it's just this court, in Souters. An act clearly inconsistent. If I can come up with, for each of these, a reasonable explanation other than withdrawal of consent, then it's not unambiguous. And for each of these, you can say, well, there's another reasonable reason.
Right.
He had plenty of time to say, hey, you guys said that you weren't going to search. Stop searching. Don't search. I don't want you to search. There's nothing remotely close to that.
Go ahead.
And and the fourth thing that I think is absolutely wrong is the judge said that because the defendant lifted his shirt to show that he had no weapons, that was a challenge to the officer's authority to search the car. And I just think that's a non sequitur. I don't really see how that holds up, how that is.
Let's go back to the recording for a moment. At one point, he offers to, hey, do you want me to get the registration for you out of the car? And the officer declines that, says, no, I'll get it myself, right?
Right,
So
and then he asked him to step back to the car.
he says, no, I'll get it myself. So that's telling him I'm going to get it myself. That's not saying, is it okay if I get it myself? That's telling him that's what I'm going to do. Then he says, well, I want to record. What's he doing in my car? And they're obstructing his view. He's trying to look in to see what's going on in the compartment of the car. And the officer keeps telling him, walk over here, and is kind of stepping in between him and the picture. He says, but I don't know what he's doing in my car. I want to record it. I want to record it. They tell him, it's okay, we're recording it.
And we're not going to steal anything. They are not so much trying to
I don't know if
I
that
don't
was
think
his
they're trying to
concern.
obstruct his view. They just want him in a place safely behind the car so that he's controlled during the search that he has consented to.
He's trying to look and see what, from my view of looking at the video, reasonable minds may differ. From my view of looking at the video, he's trying to look over the officer's shoulder into the compartment of the vehicle, and he says, I don't know what he's doing in my car. I'm looking to see, I want to record. What's he doing? I don't know what he's doing. That does not seem consistent
Well, he's
with
certainly
consent.
worried
That
about-
does not seem consistent with consent to search.
Well, I don't think it's clearly inconsistent with at all because it is susceptible to other interpretations that are just as reasonable. The fact that his car was filled with merchandise, no showing that it was ever...
in the glove box. I mean, it is filled with merchandise. He's got boxes in the back seat. They seem not too concerned with the box in the back seat.
But he thinks he reasonably could have thought, and I'm sorry if I interrupted you, Your Honor, it's a bad habit I have. He reasonably could have thought, they're going to take my stuff. Police steal stuff. My car's filled with merchandise. I want to make sure that they don't. And that's how the officers interpreted on the scene. And I just don't think, and of course this court has the final say, as to whether or not any of these acts is clearly inconsistent or an unambiguous statement. And I'm just going to rely on the language that this court has used to describe the test, both for the validity of the consent and whether or not he withdrew and the scope of the consent. And I see my time is way over. I thank you very much for the opportunity.
Hold on.
Oh,
Hold on. The stop is supposed to last as long as necessary for the limited purpose of what the stop was for, right? Well, here it is to issue a citation for running a stop sign.
yes. And then it was prolonged by the defendant's own conduct.
Because he got out of the car.
And because he said, you can search my car. Because he made the search everything statement. And that's
Why do you think he said that?
because he was because he knew that he had drugs in the car, and he thought that perhaps by being cooperative, he would show that he was innocent, and they would say, oh, okay, don't worry about it. We're not going to because you're being so open about it. That might be why he have done it. He did it. We don't know for a fact, but that's certainly a reasonable reason why. I mean, defendants and people, human beings, I myself said 7 stupid things this morning that were counter to my own interest. And it happens. People say things like that all the time. There are cases in which they say, go ahead and search the bag, and it has drugs in it. And that court said in that case that the defendant might have been thinking that by being so helpful that they would assume that he didn't know that the drugs were there.
What, if any, value do you attach to the fact that the police said, no, we don't want to search, we're not here to search?
Well, as I said, I don't attach any value to it for 2 reasons, as I've said, because he's referring to at the time they pulled him over, but that's not how you vitiate consent that's already validly been given. An officer saying, I'm not going to search, and then he goes and search. The withdrawal of consent has to be through an act of the defendant, not the conduct of the officers. When he starts searching, it is then the defendant's burden to say he's got to do something that clearly states I am withdrawing my consent, and he just didn't do that here.
You don't think his conduct suggested that?
Absolutely not. I think that it had a lot of other reasons.
You don't think his conduct suggested that he didn't want them to search his car? You think that that was unclear?
Suggest, maybe. Clearly inconsistent, unambiguous, absolutely not. So, yeah, it might suggest it, but that's not the standard for when you withdraw consent to a validly given
You don't think it was clear? Not suggest. You don't think it was clear?
No. No, I don't. I think he wanted to monitor it. I think he wanted to see what was going on and to cooperate with it, which is something shy of withdrawing that consent. So that's my argument, Your Honor.
The officer saw the registration in the glove box immediately and then continued to just kind of rifle it until they found the key container and pushed some buttons to open that?
No, he did not actually find the registration. He didn't go to the glove box.
He rifled the glove box.
He rifled the center console.
And
No, I guess he did rifle the glove box. That's correct. I don't think he took it out.
Talking about the same video,
Yes,
right?
yes, no, I'm sorry. He didn't take out the registration, but he pretty quickly went from the glove box to the center console. But that was the point of his going around the
That
car.
seems to me beyond the stop.
Well, not if you have consent, is my argument.
Gotcha.
Thank you very much.
I think that's our time. Attorney Howe.
Good morning, and may it please the court. Caroline Howe on behalf of Mr. LOVANT Wheeler. I'm going to turn to one of the Commonwealth's arguments first, about the concededly illegal pat frisk and the impact that had on Mr. Wheeler's alleged voluntary consent. So the Commonwealth says that because this was mere acquiescence to a claim of lawful authority to search the car, because the car was not involved in the illegal pat frisk, we can disregard the illegal pat frisk, and that's not true. And we know that from Commonwealth v. Yehudi Y, Commonwealth v. Laughlin, and Commonwealth v. Torres, all of which are cited in my brief. Laughlin and Torres, I believe, are car search cases, and Yehudi Y is a search of a dwelling. But all of them say, following an illegal pat frisk and exit order in Laughlin, following an illegal detention in Torres, following an illegal entry in Yehudi Y, where consent is obtained as the result of the exploitation of a prior illegality that follows close in time, so here it will be an ongoing illegality, then consent is not considered to be freely given, which makes a lot of sense. Here you have 3 officers, and I'll say that they surrounded Mr. Wheeler, grabbed his arm. The Commonwealth concedes that's an illegal seizure. And if you look at Officer Burke's body-worn camera footage at second 40, you can see him make contact with Mr. Wheeler. He reaches out and grabs Mr. Wheeler's sweatshirt pocket.
You're saying before the
Before
comment,
he makes
you
the
can search everything?
Yes, I think
Yeah.
you can clearly see that from the video. He returns to that pocket again while Mr. Wheeler's making the statement, and then he keeps searching it immediately after Mr. Wheeler makes his search everything statement. He's really interested in this sweatshirt hoodie pocket. He manipulates the cash in it. So you can see, and I think this is why the motion judge clearly found that the pat frisk started before he made the statement. You can see it on Officer Burke's body-worn camera footage.
Can I ask the significance of Officer Burke's testimony that he knew Mr. Wheeler had a prior conviction for a firearm? First of all, is that a fact? I'm pretty sure Torres Pagan, the officers didn't know the defendant. I can't remember if in Yehudi and Laughlin, I know in Laughlin they didn't know the defendant either. Can you speak to the significance of this 10-year-old firearm conviction?
So I think that the motion judge is correct, that it is a factor and it's not dispositive here. It doesn't get the Commonwealth to any kind of reasonable suspicion or any fear that Mr. Wheeler is armed and dangerous. It falls far short of that, and that's, I think, why the Commonwealth concedes that it was an illegal pat frisk.
Were the officers reasonably concerned for their safety as soon as the defendant got out of the car, which is unusual conduct for a everyday traffic stop at 8:30 or 10:30, whatever time it was? It wasn't super late.
So I think that it is unusual. We know from Commonwealth v. Torres and Commonwealth v. Torres Pagan, where the defendants got out of the car, that's not a factor when it comes to whether the person is armed and dangerous. Can the officers consider that in their own safety interests? I think that's fair, but I don't think that gets them to any kind of concern about the defendant being armed and dangerous, and we get that from SJC precedent.
So I'm not sure what that, you lost me with that answer. It's fair for them to be concerned about their safety.
Right. But I don't think that
He's
gets
armed
them.
and dangerous. What else are they, what safety are we talking about if it's
I
not
don't
that
think
he's
that gets
armed and
them
dangerous?
to. I don't think that gets them to an illegal pat. I don't think that gets them to a pat frisk, is what I'm saying. So I think their actions in moving Mr. Wheeler away from the car, fair. Their actions pat frisking him,
You think that's
illegal.
fair? You think that was appropriate for them to move him away from the car?
I don't think that was illegal action on the officer's part.
So why would they do that then? If they're not concerned for his safety relative to something in the car, then why is it okay for them to move him away from the car?
Yeah. I mean, so a pat frisk that they did was of his body, right? It wasn't of the car.
I understand.
So if they're moving him away from the car, maybe they're concerned that he could get back in the car. Maybe they're concerned.
That is what their concern is, right?
Right. Yeah, but that's not a concern that he's armed and dangerous, right? That's not a concern about a pat frisk.
It's a concern he's going to get back in the car and what, flee?
Maybe, but that doesn't have to do with the pat frisk. And I think that's, again, why the Commonwealth on appeal concedes that the pat frisk is illegal. So we have, I think we have here the Commonwealth reading into something more than a mere acquiescence to a claim of lawful authority, reading in extra words to this standard that has to do with illegal action on the part of the state. You have these 3 officers beginning a pat frisk, surrounding him, grabbing him, illegally seizing him. We have this illegal show of authority, and we have Mr. Wheeler making this statement, I think, as a result of this illegal behavior. And so
The statement is,
right.
you can search.
Right. You can search everything. And I think if, for example, a person says, search everything, and the police officers search their car, there's not a problem, right? That's a consent search. Here, though, we know from Cantalupo, free and voluntary consent, it's a factual question based on all of the circumstances of the interaction. So it's more than what Mr. Wheeler says. It's what's happening during that interaction. So here we have the illegal pat frisk starting before he makes the statement. And then I know that you were asking the Commonwealth about Officer Burke's response. He says, we're not trying to search everything. And I know the Commonwealth said that doesn't matter. I think it does. And I think it matters because consent isn't static. You make your consent statement, but you still have the right to limit the consent, the scope of your consent, and you have the right to withdraw your consent at any time before the completion of the search.
So let's take them in order. At any point, do you think that he says you can only search, or he limits the search? After saying you can search everything, does he ever clearly articulate to them, no, I don't want you to search everything. I want to limit your search to just the trunk?
So setting aside the illegal pat frisk, I think he does, on the clear terms of what he says. He says, I'm selling clothes now, look, pop my trunk, but bro, you can you pop my trunk though? I can show you everything. And I think the clear terms of that is that he's saying, search my trunk, but even if it's ambiguous, the ambiguity weighs against the Commonwealth. We know that from Commonwealth
Well, if it's
v.
ambiguous
Ortiz.
and it's not a clear withdrawing of the consent, which, because he previously had said you can search everything, right?
Right. So I want to be clear that the granting of consent and the limiting of the scope of consent, we're looking at it through the lens of reasonableness. And I know that the Commonwealth argues about this D.C. Court of Appeals case cited by this court, saying that it needs to be an unambiguous statement challenging consent, act clearly inconsistent with consent. And I don't think that that is supported by that case, Commonwealth v. Suitors, or holdings by the SJC, which says, was there a reasonable basis for police to infer the defendant had withdrawn his consent? And we know that we're in Article 14 land, we're in reasonableness land. Can we look at this interaction through the lens of a reasonable person and understand that Mr. Wheeler was limiting the scope of his consent when he says, pop my trunk? Yes. And if police were confused about where they could search, Commonwealth v. Ortiz says they're controlling this interaction. They can ask him. They can ask him clarifying questions. They can say, hey, can we search the rest of the car? And if he says yes, then they can't get setting aside the illegal pat frisk here.
I mean, we're talking about reasonableness in the lives of real people
Right.
at a stop. So I'm not sure that it would get that, as I sit here right now, that specific with respect to, you can search everything, you can search the trunk. Well, wait a minute, the police are supposed to think, well, now he's only saying we can search the trunk, so that must mean he's saying we can't search everything else. That may be a bridge too far.
Right. And I think, again, that's why ambiguity weighs against the Commonwealth, because they have the burden of justifying the search. There's no other justification for the search beyond consent, except for his consent. So the fact of what he's consenting to really matters. And that's why I think the SJC has said ambiguity weighs against the Commonwealth, but we can also look to what the officers are saying in response to these alleged consent statements. They're saying, we're not interested, we're not trying to. And so Mr. Wheeler is not going to understand later that that search is happening with his permission.
What do you think they're saying, if anything, when they try to obstruct him from video recording in observing himself what's happening in his car? Is that communicating anything to him?
Do you think the police officer's actions in blocking him and grabbing him? Yes.
I'm saying,
absolutely.
What is he supposed to take from that?
Right. I think that he is supposed to understand that he's not in control of this search. He cannot limit the scope of this search because it's not in his control. I think they've made that clear throughout the interaction. They've disclaimed any intention to search, so he's not going to understand when they're searching later. They're doing that because he wanted them to. He's going to understand, I'm not in control of this interaction. And that really matters, again, because he has the right to withdraw consent anytime before the conclusion of the search. So if he can't see what's happening and they're telling him, don't worry about it, we're not going to let you see, we're not going to let you record, he's going to think, oh, this is like all the other times the police search people without their permission. He's not going to understand it's a consent search. And that understanding really matters because, again, we're judging this through the lens of a reasonable person.
I know you probably already covered this, but I just want to make sure it's clear in my mind. There's the relevance of ambiguity in the case law doctrinally. There's two moments. There's the original consent and then the withdrawal of consent. And the Commonwealth has made clear that they say that under Sutter's, I think, and maybe other cases, once consent has been voluntarily given, withdrawal of consent must be clear. But ambiguity in the original granting of consent is in the defendant's favor, right? And so whether or not there's ambiguity, the relevance of ambiguity on the withdrawal of consent is a separate question, but there must be a clear consent, and ambiguity cuts against the Commonwealth in the initial granting of consent, right? In that you can search everything, right?
I think that would be their argument. What I will say is that voluntariness, we know, must be unambiguous.
Okay.
And they're arguing about a case that this court cited in Souters, which is Burton versus United States, which is a DC Court of Appeals opinion. And that case says that withdrawing consent includes acts clearly inconsistent with apparent consent to search and unambiguous statements challenging consent. And what I would say about that quotation is if you go and look at it in context, what this court in Souters is saying is that you can withdraw consent through actions, through words, or both. And ultimately, coming back to the same holding that the SJC has in Cantalupo, which is, would a man of reasonable caution be warranted in the belief that some limitation was intended by the consent giver? And here, as I think Justice Desmond discussed when we're looking at Mr. Wheeler's actions, you can see in the video, this is not somebody who approves of what's happening. And I think the Commonwealth's argument that he's concerned about them stealing from him, maybe he's concerned for another reason, it doesn't really matter. I think that that's a concession from the Commonwealth, that it looks like he doesn't like what's happening. And you can see that from the video, you can see it from his actions, from his words. This is something that there was a reasonable basis for police to infer here, that he did not want this search to be happening. And since it was supposed to be with his consent, since that was the only justification for this search, that the Commonwealth can't meet their burden. But again, this court does not need to get to the withdrawal of consent, does not need to get to the limitation of the scope of consent if you find that there was no free and voluntary consent in the first place. So with that, if there are no further questions, thank you.
The matter stands submitted. Thank you both. We'll take a short recess.
Court all rise, please. Court is now in recess. Court is now in session. Please be seated.
Thank you. Next matter on our list is docket 25P0722. How do you pronounce Desjardins? How do you pronounce it?
Yes.
Desjardins or Desjardins? Attorney Court.
Good morning, Your Honors. May it please the Court, my name is Kevin Kaur. I represent MARYBETH Desjardins, who came to see the arguments today. This case is about what can and cannot be lawfully included in prenuptial agreements. Illegal provisions can't be included in contracts. The same is true for contract provisions that violate established public policies. This case...
Can we start with whether this appeal is interlocutory or a final order? So as I understand it, there was a bifurcated trial. There was what the judges resolved so far is that the prenup was valid, and there has not been a divorce trial yet. And one thing, at least, that needs to be resolved is fees. The judges found there was a breach by your client for challenging the prenup, and the husband is entitled to fees, but the question is how much. That's where it stands in the trial court, right?
Mostly.
Okay.
This
Your
was
Honor,
bifurcated.
I'm happy to, I'm sorry.
This portion was bifurcated.
Yes, and that's part of the point. This issue is addressed in my reply brief, and it is addressed in the reply brief because it hasn't been raised up until the point of Mr. Cherney's, the husband's appellate brief in this case. The bifurcated judgment...
Well, when would he have raised it? Because it's your appeal. He's now that you've appealed, he's saying, wait a minute, you can't appeal. In other words, your answer just suggested that he's waived this argument.
No, I don't mean
Right,
that.
Okay, you didn't mean that.
No.
Right, okay.
No. My point is that there was no motion to dismiss. It wasn't raised upon filing. It wasn't raised in the lower court. It wasn't raised when we went to the SJC and fully briefed the issue on direct...
That was all interlocutory.
Sorry?
That was all on your challenges.
Correct.
Okay.
Well,
Okay.
Your Honor,
Anyway.
We're talking about the issue, whether we can properly hear this appeal, right?
Yes.
Correct, okay.
So,
And so
again,
your
in the-
argument, obviously, is that it is, since we're here, and so can you tell us
That's part of
what?
the argument, right. But the other part of the argument raised in the reply brief is that the nature of a judgment is determined by its characteristics, not necessarily the name given to it or the name that wants to be given to
Well, I
it
think
by...
the name matters.
Sorry?
I think the name matters.
Well, it does, and it...
To a former
Sorry.
Superior Court judge. So I want to see where this is a final judgment. Point to the strongest piece of evidence that this is a final judgment.
Well, the strongest piece of evidence, Your Honor, is that the judgment entered on a bifurcated proceeding is a bifurcated judgment, and it conclusively establishes and determines the rights of these parties in the context of a divorce. There are no...
It says that the prenup was valid and enforceable.
It says that the prenup was valid, and the prenup includes no rights, I'm sorry, the parties' rights include nothing beyond the prenup if the validity finding is upheld. There are no rights to alimony, there's no rights to property division. Every right between these parties, including the issue of attorney's fees, is governed by the prenuptial agreement.
So you're saying it can go forward because the judge, that doesn't change, all the parties are on notice of what the parameters are, right?
Correct. And the issue of attorney's fees is only under the prenuptial agreement, not under the statutes that I argue in my brief apply.
Right. We don't even know what the award of attorney fees are. We don't even know the answer to that question.
We don't, Your Honor, and we
it
don't
can't
know
be
that.
final then, right?
Sorry?
It can't be final then. I mean, how can we pass on the award of the attorney fees if it was proper, if we don't know, was it reasonable?
Well, the issue I've raised, Your Honor, is whether or not it's even consistent with public policy to include provisions in a prenuptial agreement of this sort.
Let me ask you this question, if I'm going to just interrupt you for a moment. Do you agree that wife denied in the request for admissions 20, 23 or so various requests and then admitted to them at trial?
Well, she denied them, Your Honor, and the document was put in its entirety in evidence. And there were
she denied
objections.
them under the pains and penalty of perjury, is that right?
Correct.
Okay.
And the objections were included as part of the exhibit that went in, and the objections are based on the principle that this agreement was a nullity and null and void based upon our presentation, our view, and our arguments on the evidence. So when acknowledging what an agreement said, if it's a null and void agreement, it's sort of a moot point.
So help me understand, she denied them in the admissions under the pains and penalty of perjury, and then admitted to them under oath. How do you,
Reconcile that?
yeah.
But out of context, it's hard to answer that, Your Honor, but generally speaking, if she admits that an agreement was signed by her, executed by her, it's a separate consideration altogether as to whether or not that agreement is fair. It's a separate consideration as to whether or not there were behaviors, misrepresentations, sharp practices leading to the formation of that agreement.
Wait, but I think I'm thinking about Justice Desmond's question. I think you just said, though, part of your first draft of this answer was because the agreement was null and void in your mind, which the judge disagreed with, her answers under the pains and penalties of perjury are a nullity. They never happened. But of course they happened. It doesn't, she can't assume that the judge is going to find something. She has an obligation to testify truthfully under the pains and penalties of perjury. And she said A, and then she said 180 degrees the opposite. That's not a defense to say that we argue that that agreement was a nullity. You can't bake that into your answer. In other words, is that what you're saying?
No, if that's the way my answer came out, that's
Okay.
not what I meant.
Okay.
What I meant was in the course of leading up to litigation, if a client who doesn't make the decision, a judge makes the decision, acknowledges in an admission that the document does exist, it says these things, I did sign it, that's an entirely independent consideration as to whether or not that signed document that says what it says can, under the laws of Massachusetts, be recognized as a fair and reasonable prenuptial agreement that results in the forfeiture or waiver of the strong public policies in this Commonwealth that protect the interests of spouses, spouses in my client's position, the disadvantaged spouses, when they divorce.
When you say disadvantaged spouse, what do you mean by that?
The terminology that comes up from time to
No,
time.
I'm asking you, what do you mean by that, though? How is
That-
she disadvantaged? It seems to me that these parties were on equal footing. They came, other than husband is wealthier, beyond the fact that he had wealth when he came into this marriage. They were married for 4 years. They were both going through a divorce at the time when they came together. Husband was going through a difficult divorce, as conceded by wife. Husband didn't want to have that happen again, was trying to do whatever he could do so that that wouldn't repeat itself, so it appears to me from the record. And wife was on board with that. Wife said she went through a difficult thing, and so wife was very smart, retained her own lawyer, who was very good, was referred to her by a friend of hers whom she trusted and worked with. It just seems disingenuous to say I was bullied into signing this agreement.
And furthermore, just to sort of build on that point made by Justice Desmond, the wife not only had a lawyer, but, the lawyer reviewed the paperwork, right? And wife spoke to him. She agreed to the agreement. She testified that she spoke with her attorney. He answered her questions. The wife knew what rights and obligations that she was agreeing to, or waiving, right? And she testified that she signed the agreement freely and voluntarily. So,
Right, Your Honor, and part of the whole case, my arguments in the case, is that the agreement, when it says what it says and when it includes obligations and acts and behaviors and commitments that the husband undertook and also signed on to and agreed to, but then never performed, never complied with, never did. For instance, the prudential life insurance policy that...
Whose detriment?
To whose detriment?
Yeah, what damage did she suffer from that?
I would say to my client's detriment in the sense that this was a premarital asset. The agreement made was that you make me the beneficiary, or at least half the beneficiary, and your children the other half, and I'll pay all the premiums. And then, out of spite, anger, whatever it was, he stops paying the premiums. The result is, and the stopping of the payment of premiums is the only reason why the policy lapsed.
Was
That-
it ultimately reinstated?
Sorry?
Was it ultimately reinstated?
No.
The
it was
Prudential
not.
wasn't? The
It
Prudential was not?
It was not. And it was not for lack of trying, as Judge Bahat found. Judge Bahat found, and frankly, it's astonishing to me that on the evidence that was presented, Judge Bahat finds that my client did not maintain or attempt to reinstate that policy when, in fact, both parties acknowledged that when the lapse from non-payment was discovered, my client undertook to complete and submit the application. And in fact, the evidence on the motion to reopen the evidence shows that husband even knew that reinstatement was denied irrevocably when he testified in court that he didn't know what the status of that policy was.
Let me ask you about a different piece of this. You argue that there's a different, I don't know what you characterize as a breach, but the husband takes advantage of the wife's prior employment with the county to get health insurance, and so instead of paying the $2,500 monthly premium, they're paying, I don't know, this lesser amount that is a considerable savings. Let's fast forward. So, in other words, and you make this claim, which I don't actually follow, that the wife is now going to be required to pay the health care premiums. That doesn't seem right to me, but let's just whistle past that. Move forward to a trial. Correct me if I'm wrong. The judge has the power to address that kind of a problem. The judge has the power to say, I'm going to require the husband to pay to the wife, to make it easy, on an annual basis, the cost of these premiums. If he wants to keep having this health insurance and they're going to have a divorce, let's say it's $100 a month premiums, that's $1,200 a year. On January 1st of every year, I'm ordering the husband to pay the wife $100. The judge can do that, right?
Yes, Your Honor.
Okay, so how is the wife harmed by that sort of a problem?
Well, you're at what I would consider the end of the argument.
Right, which is what I said at the beginning. Why are we here? Like, in other words, I don't know the answers to these questions, and the judge will be able to sort this all out.
Right. But if you step back into my brief, I like to think I went to great effort to establish that there are steps along the way in a case of this nature. In a case of this nature where the parties, this isn't a contract, it's not a contract that's self-proving, it's a contract that isn't anything until a court rules after hearing the evidence that it is in fact a valid contract and if valid is in fact enforceable. The parties to these contracts, they don't deal at arm's length.
Right, but you're dodging my question respectfully. My point is, this is a good example, I'm glad you put it that way. To decide whether or not this is reasonable and enforceable, in some instances, with regard specifically your alleged breaches, I need to know how the judge is going to resolve the alleged breach. There are solutions here that make it more and less reasonable. And in other words, if there's a solution to that health insurance premium problem that doesn't require the wife to pay the premium for the rest of her life, which seems unfair, then it's more reasonable. But I don't know the answers to those yet because the judge hasn't had a chance to interpret it yet. You're trying to make us jump ahead of her and say, no, we're going to decide before you answer that question, why is this not interlocutory?
Well, again, if I back up and the way I've approached this case and the way I've briefed it and the way I'll argue it now in answer to that question is if a commitment is made in a contract of this nature between people who owe each other the highest duties of faith and good faith, and honesty and candor, and a commitment is made, and then a commitment is ignored. The evidence is that my client, when she realized, oh, well, wait a minute, that's coming off of my retirement funds that I'm supposed to be able to save, not out of his pocket, addressed the husband. The husband said, I'm not going to deal with $400 a month. I'll put it in your Fidelity account. He just disregarded the contract. So in my argument, one of my sections of my argument is that the principle of estoppel, not estoppel, but the, totally lost my train of thought.
Equities, doctrine of unclean hands, what is it you're trying to
Yes, unclean hands precludes a person such as Mr. Desjardins, who comes to court in a court of equity asking a court to specifically enforce an agreement that he himself has not complied with, very much so on the health insurance issue. He hasn't, and you can ask Mr. Cherney today, he hasn't yet paid one of those premiums. It's not because she didn't ask, And it's not because the court hasn't yet ordered it, and the court could eventually order it. But my position is this.
To boil it down, your argument is a contract, at least this kind of contract, is null and void if one of the parties does something bad that violates the contract. The contract itself is null and void. It's not just a breach of the contract, it's the contract itself is null and void. That's your argument.
Well, the case law existing
What's
today,
your best case for that proposition in the context of a prenup?
the case that says, and Judge Bahati even acknowledged, or recited, I guess, the standard, that if there is evidence.
What's the case?
It's D'Amadio, Your Honor.
Okay.
D'Amadio and it's Rosenberg. They're all cited in my brief.
Right,
I
okay.
thought you quarreled with the application of D'Amadio.
Sorry?
I thought you quarreled with the application of D'Amadio. I thought you said the judge looked at the first and took the second look, but she didn't look at what was going on before the first look. I thought that was the heart of your argument.
Exactly. So the D'Amadio case, even the judge recited this in her rationale, but didn't follow what the recitation would require, says that if there is evidence that one party committed either fraud, deception, imposition, overreaching, or otherwise took advantage of the other party, then a contract will not be found fair and reasonable. That is a preliminary analysis before one gets to the question of whether or not the agreement on the first look of D'Amadio.
How do you take advantage of somebody at that phase, back at the beginning, if they've got a lawyer who's negotiating it for them? How is that possible?
Well, Your Honor, for instance, on the health insurance,
But that hadn't happened, even accepting your allegations is true, that hadn't happened until after the signing of the prenup, right?
the lack of payment on the health insurance, that's correct.
Yes,
So
right.
my point is, if you have a lawyer and the lawyer looks at that clause and it seems, okay, well, he'll be on the insurance and he'll pay for the premiums, there's nothing a lawyer can do at that point. And part of my point is, if a person such as Mr. Desjardins enters into a contract knowing he's not going to apply, or comply, I should say, that's fraud.
But we don't know that. We don't know that.
Well, I
The
think
record- And the record doesn't really support that.
Yep.
What the record supports is that they both went into this, it seems, eyes wide open, and both had counsel, and she made edits to the agreement when it was in its formulation stages. She suggested things that went back and forth, and they agreed to it. Was there any action brought against her former client for ineffective assistance, by the way, or a former lawyer?
I just didn't hear, no, there was
Any
not.
action brought against the lawyer for
No, there was not.
ineffective assistance?
No, there was not. And part of that is because the agreement was entered into May of 2019. I didn't become involved, and the case didn't start until 2024, 25. So the statute of limitations would have been long gone on any such claim. Can I move on to the issue of the counsel fees, Your Honor? I don't want to run out of time. I'm at 2 minutes. Oh, I'm past 2 minutes, I'm sorry. But if I may,
Sure.
the issue of counsel fees. In any case of this sort, the court has statutory authority, independent of whatever the prenuptial agreement under review may say. And in this case, at 3 different junctures, I brought before the court the request for under Section 217 of 208, Section 38 of 208, and the rule that applies, Rule 406 of the supplemental rules. A request that my client be afforded an allowance so that she could properly prepare the case and properly present the case at trial, just as Mr. Desjardins would be able to do with Mr. Cherney. That was denied. It was denied without reason. When I moved for reconsideration, no reason was given for the denial of the fees. Mr. Cherney even suggests that the agreement doesn't even preclude the issue of fees. And then at trial, when the judge says I can renew the motion for fees at the evidentiary hearing on the bifurcated issues, I did do just that, and the motion is denied. So at every juncture in this case, my client, the wife, was left without the resources and the ability to retain and to hire and to retain and to pay counsel to represent her through the conclusion of the bifurcated proceedings.
It seems to me that this issue of attorney's fees is at least a double-edged sword for you.
In what way, counsel? I'm sorry.
The prenuptial contract suggests that if you bring a claim for breach of the prenup, as you've done, the breaching party will pay the attorney's fees of the non-breaching party. I'm sorry, strike that. That the party bringing the claim will pay the legal fees of the party defending the claim, and then also an appellate, your opponent brings a claim to us for fees for this appeal. So in other words, there are fees, requests for attorney's fees going both ways here.
In a sense, yes, Your Honor, if you're operating under the assumption that the agreement was found properly found to be valid, and that's the provision on which you're seeking fees. That's not the provision under I was seeking
Well, I get it.
fees.
You're making a different argument. I
It's
understand.
statutory, and Mr. Desjardins has those rights under the statutes that apply in this context too, independent of the agreement. And again, that's one of my points. If you strike from this prenuptial agreement the language that penalizes a woman or man in my client's position who comes to court and says this agreement wasn't fair. This agreement, and I've cited some cases out of Connecticut which I think are very illustrative, this agreement basically says if you dare challenge the fairness of this agreement.
Either side. If
Either side, that's correct.
challenges it,
That's
because
correct.
because that's exactly what we're trying to avoid. From the outset, we're trying to avoid litigation post-divorce. So we hope that the marriage lasts, but we've both been through divorces, and at least Mr. Desjardins didn't want to have to go through the litigation like that again. And so they both went in eyes wide open and said, let's make this agreement that this is going to be our agreement. Do you have any questions about the agreement? Is everything you wanted in the agreement? You got a good lawyer, who he paid for, by the way, to help formulate the agreement. We both agree this is it. You're going to get $50,000 then, and then you're going to get this X money down the road. And she's got a company that she didn't have when she came into the marriage that she leaves with. All of these things, and that's going to be it. And we both get to walk away without any litigation.
If the terms of this agreement were in place in 2019 and they were honored in full, and there were no breaches, there were no disregards, there was no bad behavior, no breach of covenant of good faith and fair dealing, if you're at the end of the case and those things have happened, that's a basis.
Breach of covenant and fair dealing in the making of the agreement? That's what I want to hear.
Well,
in the formation of the agreement, where's the breach of covenant of good faith?
Well, I can address that. I know I'm over time, but I'd be happy to answer the question.
Please.
There was what I have described in my brief and what the evidence supports, what I call the scheme. And the scheme related to this man's desire to rid himself of the cost of his health insurance by convincing my client to stop working.
He's a multimillionaire, right?
Yeah, you're right. And it doesn't make any sense.
And there's a finding by the judge that she retired before they got married.
She stopped working before they got married. She did not begin taking the retirement benefits because, and here's another part of what I call the scheme, Mr. Desjardins knew that if the retirement benefits did not begin to come until after they were married, he would have the ability to not sign off on the retirement papers to get the health insurance without requiring, which he did, requiring my client to designate him as the survivor.
How much, I think the monthly benefit that he gets under option C as the surviving spouse is $400 a month, is that right? What is it?
That's the cost of the health insurance.
Right, sorry.
His survivor benefit is
Yeah.
$792, and there's a cost of living adjustment, so it would be
Okay, and
more
he's
than
worth
that.
$7.5 million.
Your Honor, I will say, and I'll suggest that my argument is, I'm sorry, Justice, that my argument is that it's not about the substance of what he was getting. It's about the controlling of the outcome in here and controlling of my client exercising that option C in his favor, taking it away from her children, just like the Prudential life insurance policy. Why did this man, who had $7 million or whatever the number was, $7.5 million, why did he need to make himself the beneficiary of this $500,000 policy that my client took out in her 30s for the benefit of her children? It was about controlling and taking control and keeping control. That's what this was. Now, I tried to bring that evidence in at trial, and Mr. Attorney objected, and this judge sustained the objections. I made my offer of proof. There was all sorts of other behaviors during the marriage that I wasn't allowed to get into. All of it adds up to, if at the end of the day, you have a contract that's never been complied with by the person seeking the equitable remedy, then that's a basis on which the agreement should be determined not fair, not reasonable, and set aside, and allow these parties.
You say never been complied with. She's living for free in a home that she doesn't own, right, with her 3 young children. She has a business, a cleaning company that was purchased, at least the materials to support that company were purchased by the husband, right? No, is that right so far?
No, I can address that.
Did he purchase the
No.
materials?
He
did not.
owned the vehicles, he helped her buy some vacuums, but Your Honor, this
Say
comes...
he helped her buy some vacuums, what does that mean?
He
purchased
he
them,
helped her
right?
buy some equipment, yeah.
She didn't, all right. He
So-
bought the equipment for her business.
Right, but if I can back up,
Sure.
she had the job with the state retirement system. It was a good job. She had a good pension.
But she
She
had
had
stopped
her years
working.
in.
But she had stopped working.
And she stopped working because he asked her to, and the evidence support this. He wanted her around. He wanted to travel with her. He didn't want her going to work every day. He wanted her caring for the kids. That's all part of the evidence. So the promise was that with your retirement monthly benefits, you're going to take those and you're going to put them in this Fidelity account that I walked you to Fidelity to open before we signed this agreement. And you're going to let those accumulate because by the end of who knows how long, you'll have $500,000, which you'll make me the beneficiary of. That was the nest egg agreement.
None of that's in the prenuptial agreement. That's the scheme. I read your brief. I know the scheme. I understand the scheme as you play it out. It's not in the prenup, right?
And the point is, Your Honor, and I'm glad...
So how can it be a breach of the prenup?
It's not a breach of any
And
provision
how
in
can
the
it?
prenup.
And then, if it's not, how can it render the prenup invalid?
It goes back to, again, the behaviors, the conducts, the statements,
You could be the. I don't understand analytically. You could be the worst person in the world and not breach the contract. And being the worst person in the world is not a legal basis for breaching the contract, or is it?
Again, I'm not looking at that as a breach. I'm looking at that as behavior, misrepresentations, false inducements, fraudulent inducements that went to her willingness to sign on to this agreement.
Oh, I see. All right.
Because she understood from him, as part of the scheme and this effort he undertook to get himself health insurance, life insurance, and pension benefit, retirement benefits, he induced her with those statements and then took away the support he promised, requiring her to deplete those funds, requiring her at some point to even have to consider going back to work. She couldn't get her retirement service job back because it had been filled. And if she went back, and this is an important point too, if she had gone back and tried to undo the retirement, well, now all of a sudden she's in breach of that provision for health insurance because he wouldn't qualify anymore after a divorce. But it goes to whether or not the agreement can be found to be fair and reasonable and valid after evidence of this sort of pre-execution behavior, and then the consequences of it playing out are considered in the totality of the evidence by the judge, who, I say in my brief and I'll say here, closed her eyes to most of the evidence of this sort of behavior. And she fixed and focused her analysis of the agreement's fairness on just those two provisions that said $10,000 when he kicks her out of the house and $50,000 or $75,000 as a lump sum, and that's it. Those two provisions are less valuable in the whole when you look at the agreement as a whole and what it provides to the person with the wealth and takes away from the person without the wealth, such as the health insurance.
Not if the judge orders him to pay his own premiums.
Well,
You're doing the accounting before the judge has done the accounting.
my point
The
is...
biggest money thing he could save is the premiums, but that assumes the judge isn't going to order him to pay the premiums.
It's more in the savings that he accumulated and made the promise to her that he would put into his corresponding nest egg account. So the savings of the $2,500 less the actual premium, which he hasn't paid, would go into this nest egg account. Her monthly retirement would go into this nest egg account.
I get it.
So those things never happen, and that's what I call the fraudulent inducement and the failure to comply, and the reason why a court of equity can't grant a man who has behaved this way in a case and a contract of this nature the equitable remedy of specific enforcement.
So at bottom, do I hear you say he married her for money?
No, he married her because he could save money, not because she had money, but because he could save that health insurance premium and because he could make himself the beneficiary of a $500,000 life insurance policy he didn't need. Her children needed. And now it's gone because he didn't do what he undertook to do and committed to do in the contract.
I think we'll have to leave it there. Thank you.
Thank you, Your Honor. Justices. Sorry.
Attorney Cherney.
Good afternoon, Your Honors. My name is David Cherney from the law firm of Atwood & Cherney on behalf of the appellee, Stephen Desjardins. Quite, yes, Judge. I was just going to say, quite candidly, I view this as a very simple, straightforward matter. You have two people who were on their second marriages, who were married for 4 years, 8 months, who before they got married for very good and valid and established by law reasons entered into a prenuptial agreement. Both exchanged information that was necessary. It was arm's length. They both had counsel. There were amendments made to the drafts. Both of the lawyers, the prenuptial lawyers' files were introduced as exhibits before Judge Bahad at the trial level. They signed the agreement, and 4 years, 8 months later, they get divorced. My client comes in and says very simply, we made this agreement for a reason, to avoid all of these issues of moving forward, to avoid the expenditure of the hundreds of thousands of dollars that have now been expended on this case, and I want it enforced.
They signed the agreement not on the eve of the wedding.
No, it was, I think she signed it on May 3rd, and he signed it within a few weeks before the wedding.
Let me ask you this question. What would you say to the response brief filed by counsel?
What would I say to his response of his brief?
Yes.
I think it is so full of hyperbole, innuendo, things that were not presented at the trial court level. Interestingly enough, this court is here to review the actions of the trial court, to determine and discern whether or not the trial judge created a breach of her responsibilities, an erroneous decision. There has been nothing suggested in the brief or the argument today to say Judge Bahad misapplied the evidence. Judge Bahad found something irrelevant. Judge Bahad wrongfully prevented me or prohibited me from introducing certain evidence in this case. This case was tried. It was a 2-day evidentiary trial. There were 6 separate pretrial hearings in this case before the 2 days of trial, motions, status conferences, pretrial conferences, et cetera, et cetera. And Mr. Kaur now makes a big issue about this issue of my client's non-payment of health insurance. Number one, he's got to be given the bills beforehand. Number two, although this postdates the issuance of the judgment in this case, Mr. Kaur knows very well that my client no longer is on her health insurance, and he's got his own health insurance and he's paying for it. And he knows that we have a hearing scheduled, I think it's May 5th with Judge Bahad as a status conference. I don't expect to have a decision out of the appeals court at that point, and it'll probably get continued. But the judge has kept it on because, as I think Justice Wood and Justice Desmond said, there has been no determination yet of what, if any, fees are going to be paid. I can tell you, we've asked for them. We've asked for them under the terms of the breach provisions. This is a very explicit agreement, and it says if either party seeks a result that is contrary to what is in this agreement, the presumption, not the order, but the presumption is that they will pay the costs, including reasonable attorney's fees incurred by the party seeking enforcement.
That being said, do you think we're properly here today?
I'm sorry, Judge?
That being said, do you think we're properly here today?
No, I don't. I think one of the arguments I've raised is that it is an interlocutory order that's been entered because we don't know what if anything, the judge is going to be doing in terms of fees. She could come in and say, you know, Mr. Cherney, I hear you, I know you, and I've seen what you've done in all this case, but I'm not going to order any fees. Or I'm going to say your hourly rate is too much. Or I'm not going to order you all of the legal fees that you're asking for in this case. So we don't know. We simply don't know. I'm hopeful that she'll give us the fees. In fact, in this case, while it's not part of the appellate record in this case, the judge in subsequent hearings has ordered my firm to hold in escrow the lump sum payment, and we are holding it in escrow, the lump sum payment that my client is obligated to make under the terms of the prenuptial agreement. I had argued that because if the fees are more than that, I don't want to be chasing something that doesn't come, but those have been paid. So what the judge might do down the road is very much as yet undetermined. We've made, as I said in my brief, we've made the arguments to indicate what our arguments to the wife's appellate issues are. And I don't think that in any way, shape, or form that under the standards set forth in DiMatteo, which was a case now, it was 24 years ago, this past February, was decided by the SJC, set forth criteria that a judge needs to look at, and the appeals court and the SJC needs to look at in determining whether a prenuptial agreement is valid and binding. And in this particular case, under the first look doctrine and under the second look doctrine, the judge made extensive, detailed findings of fact, conclusions of law to support her findings that not only was the agreement fair and reasonable when it was executed, which is the first test under DiMatteo, but it's also fair and reasonable at the time it sought to be enforced, the second look doctrine under DiMatteo. I don't know what else could have been done at the trial court level other than to end the case a lot earlier, obviously, than it did. That it was. We're still here. The case is still going on and on. But I think that the principles here that this court is looking at, if you're inclined to say that it's either non-interlocutory or we're still going to render our decision knowing that Judge Bahat has more to do, but the fact is that she complied with established law, going back to Rosenberg v. Lipnick in 1977, going up to Osborne in 2001, DiMatteo in 2002, I think it was.
Can I ask you a question to put up the wife's argument about the scheme, which I gather the scheme was conceived before the prenup as a means of enticing the wife to sign the prenup, and that makes the prenup invalid. Do you want to speak to that? And did Judge Bahat address that in the two-day trial?
I'd be happy to. Yes, she did address it by her findings that the agreement was fair and reasonable then and now. And also, when you look at the agreement itself, I mean, this is a 21-page written agreement that has all kinds of waivers in it. And to the extent that they made any agreements outside of the prenuptial agreement, the prenuptial agreement says those don't count. Those aren't to be considered. This concept of a scheme, I think Mr. Kaur gives my client way too much credit. My client is a very, very successful businessman. He entered into this for the very reason that we're here, to try and avoid it, I should say. And this concept of a scheme is something that's candidly, I think, created out of whole cloth because he's got no other arguments to make to support this concept. The wife was asked, you knew your husband had been going through a contentious divorce with his prior wife. She said, yes, I do. And you knew, question, that he wanted to avoid that happening in a second time if, in fact, this wedding doesn't last in a lengthy marriage. And she said, yes, I understand. Nobody should go through that, and Steve shouldn't have to go through that. That's her testimony. She knew what she was signing. And now when it's time to hold her to the terms and conditions that she agreed to in this contract, this now judicially established valid contract, I think is just a total waste of time, quite candidly. I've made arguments in my brief about the concept of pendente lite counsel fees. I will just say that on each occasion that Mr. Kaur filed a request for an allowance of counsel fees under Chapter 208, Section 17, he was denied. You'll see in the record appendix, Judge Bahat has a habit of making some margin notes sometimes on orders, and she'll say denied because or denied, etc. Then Mr. Kaur would file a motion for reconsideration or a motion for this, a motion for that. And on each and every occasion, she denied it, which was within her discretion to do. There's no mandate under Chapter 208, Section 17 that counsel fees be allowed as an advance. Typically, it's just that. It's allowed as an advance against what they're going to get under the terms and conditions of the judgment, potentially, or in this case, maybe under the terms and conditions of the prenuptial agreement. There's no place that she made findings that the reason I'm denying this request is because the prenuptial agreement prohibits it. She denied them within her discretion under the mandates of Chapter 208, Section 17. At the end of the bifurcated trial, when Mr. Kaur filed a motion for counsel fees under presumably Chapter 208, Section 38, which is another statutory provision for the court to be able to award counsel fees. That was argued, that was briefed extensively, it was opposed extensively, and it was denied. It was denied. His motions for reconsideration were denied. And now that we're here, we're faced with this argument about some type of public policy against what he declares a, quote, penalty, unquote, clause in the agreement. That's not what the provisions of the counsel fee breach in the agreement provide for. It says if somebody seeks a judicial action that seeks a different result than what this agreement provides, then, as I earlier indicated, the court has the ability to assess costs and fees, including reasonable counsel fees. And that's what we hear about. Mr. Desjardins could also file a request for fees under Chapter 28, Section 38.
Hasn't he?
Well, we have filed a request for fees. We've had several affidavits post-judgment that have been filed, and I'm hopeful every time we get in, the judge did, I'll let the court know, she did issue another bifurcated judgment that granted the divorce. So the divorce, which has normally stayed pending appeal, has become final in this case. But the practical reality is that he could seek it under 28 Section 38, but we're seeking it under the terms of the provisions because there's already been a judicial determination, not only that the agreement is valid, but that she's breached, and as a result of that, she's responsible. That's one of the things she gets. And Mr. Kaur talks about the disadvantaged spouse or whatever. DiMatteo is very, very clear in saying that there are occasions where it may not create an equal division of assets, or it may create a lopsided division of assets. But as long as you meet those criteria that we've established in the first and second look, then we're going to uphold the terms and conditions of the prenuptial agreement. I know I haven't used all my time. I think to the extent I haven't addressed any specific issues, I'd rest on what's in my brief. Clearly, if the court has any questions, I'd be happy to answer them for you or try to answer them as best I can for you.
Hearing none, the matter stands submitted. Thank you both kindly.
Thank you very much, Your Honors. Appreciate the time.
Next up is 25P0768, RFF Family Partnership and another versus Shops at Saugus LLC and another. Attorney Briansky.
All set. May it please the court, Your Honors, Richard Briansky on behalf of RFF Family Partnership and Saugus Developer LLC. We are here today because of a so-called mitigation covenant. This is not a traditional restriction, a regulation, or a zoning law, nor is it a standard form of agreement. In fact, most practitioners hearing the name mitigation covenant have never heard of it before. That is because it was specifically created to allow the town of Saugus to impose certain restrictions on the development of property in exchange for rezoning.
Well, I'm struggling right off the bat because you say it was created to allow the town of Saugus to ... But your opponent will say, no, it was created by your opponent, by shops, in order to get the town to let them build the thing they wanted to build. And there's obviously a tension here. The whole point of this, the whole dispute is whether or not this was created by the town. Why do you say it was created by the town as opposed to by the shops?
Well, I said, because if you read the agreement itself, in the agreement, if you look at the plain language, it manifests the express intent that the town, through the planning board, requested these specific conditions. And this is not extraordinary or an ordinary. In fact, there's nothing wrong with exactly what the town and the shops at Saugus did here. This is what they call contract zoning. In fact,
standard practice, right? I mean, this is not unusual.
Not unusual at all. And our problem is this. It is the standard that the judge used in terms of evaluating the evidence. There's a standard that's almost insurmountable when you're talking about contract zoning. Because contract zoning, by its very nature, is informal. You're dealing, and when I say informal, there's no board that's going to approve it. There's no, and that's been the challenge to contract zoning. Rather, what it is it's communications between both the town and the developer about what they want to get. And one wants the zoning, the other wants certain concessions. And the way, at least this court, the SJC, has described contract zoning, and this is in one of the series of cases, but they all basically say it's the extraction of a promise by the town in exchange for this rezoning, which is exactly what we're claiming here. Our problem is, and let me be really specific, is the standard the judge used in evaluating the particular evidence that we introduced. And the standard itself is so high, he could have dismissed our case at the time we filed, because we never would have had anything from the planning board identifying these particular restrictions, which is exactly what the court asked us to do.
So let me just ask this question. The shops, they crafted the mitigation covenant. They wrote it. Is that fair to say?
That's fair to say, but all right, sorry, go ahead.
The town didn't write it.
That's correct.
The town's lawyer didn't approve it.
Town lawyer did not.
They didn't get the pass on it. They didn't sign any document to that effect.
That's correct.
The shops crafted this because I think you started with the town crafted it, or the town came up with this mitigation covenant for them. But isn't it the shops came up with it to benefit the shops? The shop said, if we have this area that won't be impacted by traffic and whatever, we leave it that way, we'll be able to build our mall, or whatever it was that they were doing.
That's certainly what the judge concluded, but I think that's in isolation. And because in every time you're going to have one of these particular, what I call contract zoning type cases, you're going to have this exchange. And you're going to say, your conclusion is, well, it was voluntary. The shops had suggested it, the shops drafted it, the shops submitted it. But that sort of ignores the practical reality of the situation, that there was ongoing discussion between which often happens in contract zoning.
They have town meetings, and this one was an open meeting. Come one, come all. What are the issues? What are the concerns? What can we do to put them at ease so that we can have our mall?
And our specific focus, our specific challenge is whether the town, when it's entering into these negotiations, because it does regularly enter into these negotiations and it doesn't do it formally through the planning board, whether those people who are negotiating, because if you read this contract or this document, which the judge characterizes as a unilateral grant, when you read it, it certainly wasn't crafted solely in isolation by the town, by the shops. There was obviously a product of negotiations from the
Sure,
recent.
they knew what the town wanted from them, correct?
Exactly.
So they did this in response because they wanted their project to be approved,
So-
but that doesn't mean that it was coercive, right?
Well, the question is the question of voluntariness. Was this something that they, was it a benevolent, which is what the characters, if there's no town action, as the judge suggested, and this was sort of a benevolent gift, something that was completely voluntary and volitional, why would it be contingent?
It was a contingent gift.
Sorry, I
It
didn't.
was a contingent gift, right? They said, listen, we're prepared, if you, essentially, and this may be your argument, the kind of quid pro quo, if you allow us to build our mall, then we'll ensure that there's no additional traffic by offering up this mitigation covenant.
Then really what we're talking about, what voluntariness means, because it is an issue, it is a sliding scale. There's completely voluntary, which means that they gave it unconditionally. You would argue in that case, if
They
the
could
document
withdraw it.
itself.
If it didn't get approved, I'm sorry,
Yeah,
I left that out. If it
you're
doesn't get
having the
approved, we can withdraw it.
So we
or it voids.
can conclude based on the plain language of the agreement that it wasn't completely voluntary because it's conditional, which means what sort of level of pressure, what sort of back and forth happened. And I think that's an issue of fact. That's what we're identifying here.
Is there any evidence that there was a negotiation? You just said negotiation. My understanding of the record is different. My understanding of the record is that it's undisputed that after having conversations, maybe at the shops held it to ask for an open meeting, something like an open meeting with anybody could come, and people started giving concerns. The shops took that back and created the grant, the mitigation covenant, drafted it, and then presented it. Was there, is there evidence of emails back and forth with anybody?
No,
What's the evidence of a negotiation?
The evidence of the negotiation was both by the town lawyer.
Specifically, what?
It's his testimony in there that there was some, when you say negotiation, no, there's no evidence of negotiation like you're saying, but I look at
You use the word negotiation. I'm not trying to trip you up.
No, that's a fair, and I say, I look at the document itself, okay, because we can make inferences.
Yeah, I've got the document here, right. And let's talk about the document here, because if we're using, I agree with you. Look at the document here. The shop says, okay, we've got a proposal for you, town. Here's the proposal. We volunteer to do all these things if you give us the zoning variance that we want. And if you give it to us, we'll do these things. If you don't give it to us, we withdraw this. Take it or leave it. How is that the town coercing the shops?
It's how we got there. And that's sort of where...
Wait, you mean what happened before? You mean the drafting of the document?
I'm saying that the whole process, this document doesn't exist in isolation.
Okay, what's the evidence of the process that is coercive?
When you say coercive, I guess
the case law requirement of a regulatory taking.
Well, okay, and I sort of, if you look at the case law, and I go back, because to me it's analogous when we're talking about this sort of contract zoning, they talk about extraction of a promise. This is not my language.
Right,
it's the
no,
language
I agree, extraction of a promise, yes.
And look, you can say, we can always say, because this is subjective, was it voluntary or not? It seems to be an issue of fact. And yes, on some level, it was completely voluntary. Someone got, and just like any contract that you sign, and any time you're talking about this contract zoning, it is voluntary in the sense that there's not sufficient evidence of like duress to overcome free will. It is free will that's being used to execute.
You want the proposal accepted and approved.
Yeah, but it's both ways. The town also wants these particular limitations. This wasn't made up out of thin air. This was based on specific discussions.
I mean, did the
with
town
agents of the
care?
town.
Did the town have a dog in the fight whether the shopping complex was built? My impression is the shops wanted the shopping complex built, and the town. They presented it as a zone. We need a zoning variance to build this thing we really want. And the town meeting, there's some people going, it's going to create problems. It's not the town saying, which seems really important to me. It's not the town like, we're going to force you to build this thing. That didn't happen.
But I don't think that's the type of extraction when you're talking about government action and regulatory taking they're looking at. I mean, because it often happens with regulatory takings in these types of situations where there are these imposed. I say imposed, I know you're going to say, well, there's no evidence that they imposed them, but the language of the agreement itself, even in the recitals, which set context for the particular document, says that the town acting by and through the property has acknowledged that certain conditions be applicable to the property. Now,
where are you? Can you
it's the fourth or fifth recital down, the town acting by and through the planning board. Do you see that?
You're in the covenant. You're in the mitigation covenant.
I'm in the mitigation covenant itself because I look
What
at that.
What paragraph are you in?
1, 2, 3. The fifth paragraph down.
Fifth paragraph. Numbered 5? Okay. Sorry, go ahead.
So there is, it's not completely in isolation. And the town didn't reject, even though it's drafted as a unilateral grant, there are specific conditions of the grant in order to accept it. And I think this is significant because it almost makes it like a bilateral contract. They knew what they were doing when they drafted the document. From the title to the whereas clauses, this is contract zoning. They read all the case law, they were very familiar with it, and they made this document in a way that wasn't going to impact the vote itself, because that's what they were concerned about. My concern here is that this, call it what you want, and whether you're going to claim it's voluntary or not, it has an express impact on RFF's property. There's no doubt that at least at a minimum,
on that point,
I should never say there's no doubt because there's always doubt. I wouldn't be here.
I'm glad you shifted the lens because I'm looking at this in yet a different way. At the moment of this of the creation and the mitigation, the property that became the RFF property was vacant. And it did not have the easement it needed, that it wanted to build whatever it wanted to build, right?
That's correct.
And this is all in the context of regulatory taking. So here's my question. At the moment of the granting, the execution of this document, what was taken from RFF? that they previously had?
There was, RFF didn't own the property at the time.
No, I mean, right, fair point, but from the previous owner. My question is really a comment. It seems to me that there was nothing taken from RFF, because they didn't have the easement that they now want.
The ability to gain access through the easement, which I think is a right that exists. And
They
that's
already
how-
had a right. I mean, correct me if I'm wrong
They
here.
had a right, but it wasn't a developable, that's totally correct. But
Right.
it wasn't one that was a practical right in the sense that you could never have relied on it to secure the type of access they needed to develop the property.
And does that matter? Did they, given that the land court concluded that they did have a easement as of right, and so now they did have access, does it matter that the land court, or that they need, the easement that they want for this had not been created? I'm sorry, I'm not asking that question well.
I think I'm going to try, I think
Yeah.
I get where you're going.
Yeah.
And why isn't that sufficient, and why is there a taking, and why has RFF been harmed at all, given the allegations in light most favorable to me?
Yeah.
Okay.
Yes.
So the way I'd say it is, we have, as a bundle of our rights, this ability to negotiate with an abutter and get the easement. That was taken away from us. It was taken away from us for a specific purpose. And the way
You have the ability to, I agree, I'm mostly with you. You have the ability to negotiate with, ultimately, RFF, with the shops. You have the ability to negotiate with the shops to get the easement you need. But that doesn't mean that, and the shops has to give you, you don't have a right to take from the shops the easement.
You're totally right. But that was taken away from me, and that right, we have said, is really significant in this case, because we ultimately did get the easement that was subject of this discussion. That easement would have been sufficient to take a property, let's just say it was worth $1, and make it worth $100, which was a significant right to us. One which we would have assumed we would have had when we took over the property. One which was taken away from us for a specific intended purpose, and that was to render this property essentially landlocked and open space. That is manifest the intent through the letter in 2021. That was the
Does it matter that your opponent will say, they are not landlocked? They keep saying they're landlocked. They're absolutely not landlocked. First of all, they have these easements. Well, they have the easement we talked about, but they have these easements back in the residential area, and they can build residential units worth $7.5 million, which is only a little bit less than the thing they want to build, which will value it at $9 million. So
to that, I say, Your Honor, that's an issue of fact, and that's one that and that's sort of why we're here. Like, when you read about regulatory takings, especially the one we're bringing in, the Penn Central factors, they are inherently factual. Even all of these things that we're talking about, whether it was voluntary, how voluntary it was, whether it was coerced, aren't these all issues of fact, and aren't we entitled to have a trial on the merits of this case? That's all we're asking for, and we're asking that the court remand it. I do see my time is very short. The only other thing I wanted to hit is our motion for reconsideration, and I can make that extremely brief. And it's the same thing I asked to Judge Salinger. Show me in any of the briefs, either our brief or the other brief, where either side asked for declaratory relief. And the problem is we were never put on notice about the maybe you'll find it, I looked for it and I didn't. And then I raised it with Judge Salinger because to me this is significant because it introduces something that Judge Salinger went out of his way to say doesn't exist in the record. And that is the specific adoption by the town of these particular covenants. There's no evidence of it.
No vote.
No vote, no nothing. And he makes a big deal about it when our motion for summary judgment is being heard. And then he goes out of his way to grant this additional relief, which we had no notice of. And at some point, to the extent he was going to enter that additional declaratory relief, which is significant in this case, because if they never adopted it, they don't have the right to enforce it. We never had notice of it. And then when we tell him, Judge, we didn't have notice, give us a chance, where's the evidence? He doesn't say where the evidence is. Instead, he says, you had notice, and I'm entering judgment. Deal with it in the appeals court. So I think you understand the issues. If there's anything else, thank you very much for your time.
Thank you. Attorney McCoo?
Good afternoon, Justices. Patrick McCoo for the Town of Saugus.
Good afternoon. Perhaps you'll pick up where your brother left off. What do you say with respect to the declaratory judgment?
Where my brother left off and where the court properly left off is the motion for reconsideration is not a place to bring up new theories that you could have brought since the beginning of the matter after you lose at summary judgment. If you had it all along, you were required to bring it all along. That was a proper exercise of discretion by Judge Salinger to say, no, this is not the proper form or time to bring this argument anymore. You had your chance. And I would additionally point out that RFF in litigation against shops proceeded on the exact opposite theory that the mitigation covenant was valid and enforceable, and received a favorable judgment based on that theory in that litigation, and they should also be stopped from completely reversing course in this matter. Now, if it would please the court, I'll start back at the beginning, and I think at this point my brother has bypassed the per se regulatory taking issue, that there's no value whatsoever in the property. I don't think that's any longer a live issue, but just so the record's clear, there's clearly at least 6 acres that have viable use for the property. There's no evidence offered otherwise from my brother that it's not, and that's without even going to the approximately $7.5 million valuation by RFF's appraisal, which has no evidence against it by RFF at this point.
Right, so on the regulatory taking argument.
Right, so turning to the actual core of the dispute here on the regulatory taking, pardon me. The line and where everything comes to the fore here is that the line in the case law has been coercion versus persuasion, which I don't think there's any dispute on the law here. It's whether that actually is met or not and whether there's actual final government action. Our position, as the trial court found, is that we didn't do anything. The town didn't do anything. RFF did. They wrote a mitigation covenant. My brother made reference to recitals in the mitigation covenant. The town didn't write those. RFF wrote those. It talked about the town, but the town was not involved in that. There's no evidence of negotiation.
Isn't there some language in the record that says, without it, the mitigation covenant, I don't think that this property would have ever been approved?
So that would fall into, based on the case law, information or advice, which according to Taylor versus USA, which is a case with the FAA, where the FAA gives a developer information or advice that, I'm not sure this is going to work unless you do X, Y, or Z. That doesn't amount to a taking according to takings jurisprudence. That's not a negotiation. That is not an extraction. That's just talking, which is what happened here. Continuing on. There's no record evidence, as I think we've been addressed here today, that there was anything from the town to enforce or extract any value here. I know there was some reference to contract taking now. One, yes, that's the general aspect of a town negotiating, which did not occur here, but with property owners about what to do with that land is a common and valid event. We've cited that. It's also that labeling is eschewed by the Supreme Judicial Court at this point as outdated. You simply look at the established takings jurisprudence, in this case regulatory takings, which again is just the simple line of, is it coercion, is it pressure, or is it merely people talking? If it's the latter, it doesn't arise to any final government action, and there's simply no taking that can occur.
Is there taken, summary judgment phase, facts taken in the light most favorable to your opponent, an argument that the mere talking is town meeting members saying effectively, we know what you want. We're not going to give you what you want unless you give us what we want. And in other words, tone becoming coercion. Is there an argument that a reasonable fact finder could find that this was coercive behavior?
Well, not here, and I'm hesitant to adopt or go there because that's not the talking that's happening here.
Okay.
It's just general mutterings of concerns at a concern level. It's deliberation, which people should be free to do, especially in town meetings. That's the entire point. We're not crossing the line of, oh, I think I can get one over on you and extract this. That's not this case, and there's no evidence of that being this case. I would suggest to the court, if that case comes along, that's where the court should address that line drawing exercise.
In other words, I'm trying to, right, and I hear what you're saying, not this case, but I'm trying to hypothetically conceive, if there had been deposition testimony that a town meeting member had said to a lawyer for shops, I understand, not this case, but look, this is not going to happen. I know how to make this happen. If you want this to happen, here's what you need to do. Is that coercive?
Again, that would, for one, probably still fall into informational, and two, it's one town meeting member. You need a 2/3 vote in order to affect that. I would think you'd need more evidence than one person claiming, speculating that that's the case. That's still a little far-fetched for my position on it.
So can you resolve it on summary judgment?
Yes.
Do we know who suggested the language that goes into the mitigation covenant? This happened at an open meeting, is that right?
There were three. There was an initial open meeting. It was referred to as special meeting, and I believe there was a third meeting, and then it was approved on a fourth meeting. And I'm sorry, what was the underlying question?
Is there a distinction between a town meeting and an open meeting?
I don't. I'm not entirely sure, Your Honor. The special meeting, I believe, was more for purposes of it involved a site visit. So there were special circumstances there, but I don't believe there are restrictions. People are free to speak.
I may be responsible for a little bit of the confusion here. I think I might have said open meeting. I was trying to characterize the record. That as it was my understanding that the shops asked for some sort of meeting in which anybody with an interest could come and speak at this meeting and convey any concerns they had. The idea was it was sort of like a listening meeting. The shops wanted, this is my understanding of the record, that the shops wanted to understand what people's concerns might be.
So
I don't know if that's the best I can do.
That's exactly right, Justice Wood.
Right.
It's that there was a meeting. This was not, I don't believe, the only agenda item on the meeting.
Okay.
I got the same impression, though. I got the impression that there was a town meeting where it came up, and then, or maybe they was going to schedule a town meeting, and then the shop suggested, why don't we have this open meeting? Let's hear from everybody. Come one, come all, and we'll talk about this.
That may have been the second meeting to which it was referred after.
Here's I'm on your brief, page 9, second paragraph. The town meeting voted to refer the application to the planning board for further discussion so that the board could make it a non-binding recommendation to town meeting. This prompted shops to propose an open public meeting to give all interested parties, whether town meeting members or not, a chance to raise concerns about the proposal. At the public meeting, blah, 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 people started expressing the concerns that I think ultimately ended up in the mitigation covenant. I'm not suggesting, I'm just sort of asking, I'm just asking, I think the process was shops' lawyers are there saying, okay, what are the concerns of you people here? We'll address those in the mitigation covenant.
So, sort of, if you look at Attorney Magnan's deposition testimony on this, what he says is he was reading the room at this meeting, that he did not think there were votes in the room for it to pass, and so he withdrew it voluntarily.
He knew what was going to happen, right? And essentially, he got a sense of what, based on people's concerns that were raised.
Going to occur, and then referred it to another special, asked it to be reserved for a further vote, at which point he, attorney for RFF, came up with the mitigation covenant, came back with it, eventually was presented.
Wait, you just said the attorney for RFF. I don't think you meant that. I think you mean the attorney for the shops?
Excuse me, attorney for shops, yes, I apologize.
Right, okay. So the attorney for shops comes back with a mitigation covenant, right?
Correct.
Right, okay.
Can you go back to the declaratory judgment issue?
Really?
So the town never asked for that decision to be made, correct? And then it was only at the motion to reconsider. Parties were never actually heard. The judge never heard argument specifically, correct?
On whether the mitigation covenant was valid?
Yes, correct.
So that was not an issue that was briefed leading up to it. It was not a summary judgment issue. There was not discovery on this issue. It was never a theory of the case from RFF. So that's correct, but only because it was never part of the case from the very beginning.
So then,
RFF's election.
so was there enough then? So why did the judge do what he did then in terms of, if there's no need, was there, I guess your opponent's arguing that the judge, there was a mistake for the judge to do that. And your argument is?
My argument is that my brother's motion for reconsideration was untimely procedurally. He waited too long to raise the issue. If he wanted to bring into the case whether arguments from his client about whether there was a valid and enforceable mitigation covenant, he should have done that earlier on in the case, which is what the case law regarding motions for reconsideration states.
So I don't hear you saying that it wasn't appropriate for the judge to make the declaration, or that it was appropriate. I don't hear you saying it was appropriate.
Well, I would say, one, yes, it is appropriate, and two, what's on appeal is the motion, denial of the motion for reconsideration, which is what I'm focusing my argument on.
You got a few more minutes. Anything else?
If there are no further questions, Your Honor, I'm prepared to rest my brief.
Hearing none.
Thank you.
Stand submitted. Thank you both. The final matter on our docket this morning is 25P1078, Blackman's Post Homeowners Association and others versus Nancy BLACKMAN CALL and others.
Thank you, Your Honors, and may it please the Court. Donald Solomon for the plaintiffs and appellants in this matter. I want to, unless the Court prefers otherwise, I'd like to begin by discussing the defendant's various characterizations of the settlement agreement, because that bears on two issues. One, the issue that they waived their claim of invalidity, and also on the issue of good faith in the various communications they made to the tenants.
This is the 1988 agreement, or 2014? Which agreement was that?
Yes, the defendant's characterization of the 1988 agreement. In some ways, that strikes me as the equivalent of Schrodinger's cat. It's both exists and it doesn't exist, and you can choose one depending on your point of view. In the appellee's brief on page 31, they say the agreement lapsed by operation of law on March 22, 2018, and the parties could not, by agreement, restore it to life after expiration.
That's because it's beyond the 30 years.
That's right. And they say, nor could it be restored to life by execution of an agreement for judgment in the 2014 litigation, which was a few months after the 30 years passed. Then on page 37 of their brief, they say in the 2018 agreement for judgment.
2014, it hadn't expired yet.
Well, when we say the 2014 litigation, that litigation started in 2014, but it concluded in 2018 with the agreement for judgment.
Okay.
And they go on to say in the agreement for judgment, the parties stated that the 1988 agreement was still in force and had not been amended, the language that we referred to several times.
And that's true, right?
And it was true because they said it was true. And they go on in their brief to say this was a true statement as the 1988 agreement was still being observed by both sides. And then on page 39, they say it was still being honored in 2020 by the defendants. But then on page 45 of their brief, in discussing the issue of whether the various notices were confusing or deceptive, they say, in May and June 2018, there was no full challenge to the enforceability of the agreement in play, and no court had entered a decision finding it void. The same situation applied when they say this court, but they mean the housing court, issued its November 22 opinion after trial because the governing ruling in this action was still the earlier summary judgment decision that did not invalidate the agreement. So they're they're saying, well, we honored the agreement, that various discontinuance and other notices that refer to the agreement were not deceptive because the agreement hadn't been finally declared invalid. But at the same time, they're saying that they're entitled to treat the agreement as a nullity beginning actually after the litigation started, is when they raised their declaratory judgment claim, and never said anything about that in the discontinuance notices. They did make a...
Never said anything about what?
About
that the agreement had expired?
That the agreement had expired and that they were no longer obligated to honor it. And in fact, they did honor it. And they say they honored it for about 2 years, at least, after they say it expired.
But that can, both of those things can be true, right? It could have expired in 2018, and they could have continued to honor it on their own past 2018.
But then to turn around and say it expired 2 years ago, when they've made representations to the tenants that the agreement is in force, the agreement contains provisions that, for example, the Tenants Association had waived certain rights of the tenants in that 1988 agreement. And they refer to that in one of their notices, saying the association waived rights on your behalf. And to say that in June 2018, and in May 2018, and even in March 2018, after the 30-year deadline had expired, to say that not only says that they're honoring it, but it conveys a reasonable impression that the agreement is still in force. And then they signed the agreement for judgment in May of 2018, saying the agreement's still in force and effect and has not been invalidated by anyone for any reason. And with not a word of an argument that we think it's invalid, or we're going to contest its validity. They simply say nothing about it, and the reasonable impression that's created is that the agreement's in force, they're relying on it, the tenants are relying on it, and we have a difference of opinion about what it means.
So therefore what?
So therefore, first of all, they by that conduct, they've waived the right to challenge the agreement.
Forever?
I believe so, because they've already...
Well, how can that be fair?
Forever? That seems
fundamentally
crazy.
fair?
Well, because at least as far as the issues in this case are concerned, they've already led the tenants to believe the agreement's in force, and they're discontinuing it not only pursuant to the statute, but pursuant to the agreement. And they're commenting that the agreement waived certain rights. And in that, I would characterize that as inequitable conduct. And the statements that the agreement is in force are statements the tenants are entitled to rely on.
Let's put that, I have a question kind of 10,000 feet. Is this population of tenants the population that the statute was designed to protect?
The housing court judge so ruled in the earlier litigation. I believe that's in the record. I don't have the reference to it.
The vacation home folks, that's what we're talking about, right? Seasonal?
They are seasonal tenants. They are certainly, the argument has been made by the defendants that they are well off. I don't know that they're well off, but they are certainly not dirt poor people. But the principles are the same, as the Attorney General comments in
Right, the Attorney General agrees with you that this population is covered by the relevant statute.
And the Attorney General has taken that position for a number of years, going back to the 80s, that this is not a population outside the normal protection of the statute. And the housing court judge so ruled without challenge in the earlier litigation.
All right, and so it's your position, I think, correct me if I'm wrong, that they have to continue to run the park.
Yes, actually.
Until they're financially bankrupt.
No.
Or they sell it.
Well, what this court previously held in the earlier appeal is that if the settlement agreement was still in effect, it absolutely prohibited discontinuance prior to sale. And
That was because of the, that was because,
that's because the agreement says nothing about being able to discontinue. It simply says you're going to continue operating the park.
Wait, but I think,
I
think you maybe just said this, but you've also definitely said this, I think, in your briefs. You're not saying they can't sell.
No.
Right. It's more a question of the
Procedure.
process. Procedure, right.
Yes,
There's a procedure they have to follow, correct? That you're arguing they did not.
I have to follow, and I believe the Attorney General emphasized this in the amicus as well, is that they have, under, the Attorney General is proceeding under the statute, but under the agreement, the mechanism is that, that number one, if the property is not being sold by a certain date every year, they must enter into tenancies for the summer season. If the property is being sold, they must give the tenants notice of that and opportunity to exercise the right
of first refusal. Right.
Right. No, I think we got all that. I want to cut to the chase, because this is complicated, and we got a lot to cover. One of the family members, the Blackman family members, testified under oath at trial, or there was email. It's clear that their position is, we want to remove the families and, quote, the clutter before, which I think means their homes, before we, tell me if I'm wrong, but your opponent will. But, and then we want, once we've got it clear, we want to put it on the market because we can maximize profit if we have a clear piece of oceanfront property. And that's what you're objecting to, right?
Yes.
You're saying and I think you're saying, to cut to the chase again, you can sell it. You have to give us notice, and you're arguing about whether they've given notice, and you have to give our clients a right of first refusal. And there must be a sequence. And the sequence is, under the statute, tell us all you're planning to sell it. The discontinuance is to sell it. And we're going to get an offer before you leave. And then, once we have an offer, you have a chance to, under the right of first refusal, to match it or to beat it. What part of that are you?
The only thing I would quarrel with, Your Honor, is that if they're going to sell, they just go ahead and sell. They just go ahead and find a buyer, get a purchase and sale agreement, and then present it to the association under the right of first refusal, and let them decide whether they can or will exercise the option.
I don't understand how is that different than what I said? I want to understand. I'm not trying to pick on you.
No, I think the only difference is that if they can't, under the statute, under my interpretation of the statute and the Attorney General's, they can't say we're discontinuing in order to sell. In other words, they can't start that two-year period running.
have a buyer.
They have to have a buyer and have an agreement, and then let the association buy it or not at that price.
So you have no quarrel with that sequence?
Not at all.
Right, okay.
And in fact, the settlement agreement, the 1988 agreement, provides in paragraph 10 that if the property is actually sold to someone other than the association, then all the tenancies terminate 60 days later. So the argument that they cannot, that a buyer is not going to want to go through this long process and incur costs and wait to do whatever they're going to do with it, that's not a factor.
Right.
And it's speculative, right?
Well, I'm sorry, Your Honor, what's speculative?
And it's speculative. I mean, they don't know what the buyer's going to want to do or not do because they haven't come forward with a buyer yet.
They don't necessarily have to know what the buyer's going to want to do. The buyer might just say, I'm offering X amount of money for it, and I'll do with it whatever I choose later.
Their goal is to get the highest price for the property.
Yes,
I mean, they say that.
Yes, and nothing in the settlement agreement or the statute prevents them from finding a buyer who will use the property for anything and entering into a contract and giving the association their right of
So they don't need, what you're saying, I just want to make sure I understand, I think that's important. You're not saying that they have to find a buyer who will continue to use it as a mobile home park.
No, they do not.
Right. They just have to find a buyer who makes an offer, a good faith offer, and then they have to disclose that offer to the Mobile Home Park Association. Right.
And the buyer might have, an issue with whatever the process is, but that's true of any real estate.
What they can't do under the statute is clear everybody out and then refuse to renew their rental agreements and remove their homes or force them to remove their homes and then clean it off and then put it on the market. That's what you're saying they can't do.
Because that frustrates the exercise of the right of first refusal.
Right.
And that's true under both the statute and under the 1988 agreement.
Right. So if that, and yeah, right. On that point, what does it matter if we say that the judge found that the 1988 agreement is void? Like, okay, but if we say that the statute requires what you just laid out, what is the value? What work is the 1988 settlement agreement even doing?
It's prescribing how the park is run. It's prescribing rent increases during whatever period of time it operates. So the tenants have significant rights under that. I see time is running. Unless the court has other questions on this, I just want to get...
Those rights also include with respect to the notice that you have to, the seller has to kind of survey other parks within a 100-mile radius. And is there anything that says that that has to be within Massachusetts?
No, it doesn't. My recollection of the statute is it does not have that requirement. But the first survey that they did was only of parks within a 50-mile radius. And they're claiming that that was a valid notice. And so that notice is out. So they did not do two valid notices because the last one was too late. And there was only one actual valid notice that was posted of a 100-mile radius survey. In addition, they didn't give 2 years' notice to every tenant by delivery by certified mail.
But at this point, doesn't everybody know? I was struggling to understand. What's the reality on the ground right now? I'm sorry if I can just ask it. The reality on the ground right now, folks, the park is still being operated as a mobile home park?
By stipulation.
By stipulation. And so assuming we don't get our decision down by May 1st, the folks can renew their contracts for this year, right?
Yes.
Right, okay. So I'm struggling to understand what any of that matters, how all these violations you're talking about matter. Like everybody knows the deal now, right?
I think perhaps if I go up to the 10,000-foot level, it matters with respect to every discontinuance of a mobile home park that you want to make sure the tenants get 2 full years' notice, that all of them get notice.
But they've had lots of notice by now.
These tenants may have. I don't know that for a fact.
Oh, there are new folks who've come in, for example.
But when another park starts to do a discontinuance, if they think that they can satisfy the 2-year requirement by simply putting things in the mail and not worrying about whether they got received or not, that's a problem. And it's a problem that any eviction lawyer who serves a notice to quit knows how to solve. You just allow enough time and you do personal delivery if you have to, but you don't just drop it in the mail and say, I've done my job.
Understood, thank you, yeah.
And if I may, I know I'm a little over, but
in fact, I see that's your time.
All right.
I'll have to leave it there. Thank you.
Thank you, Your Honor.
Any Broadley?
Thank you. Good afternoon, Your Honors. In light of the discussion I just heard, I need to skip to the end of my argument and strongly disagree that there's a priority in the statute about how the owners have to pursue discontinuance and sale. The statute has separate sections which govern discontinuance and which govern sale.
But
doesn't say
discontinuance for sale. It seems to me clear as day what your clients want to do.
Absolutely.
And they said it, and the appeals court acknowledged it the last time you were here. It's clear. We're not disputed. There's no dispute. We want to clear them off, and then we want to sell it, right?
Yes.
Right. So to maximize profit.
Yes.
Right. So I'm struggling mightily to understand your distinction in the statute between, I understand there's two prongs. There's the sell rules and then there's discontinue rules. But it seems clear as day that the discontinue rules are not, it's got to be discontinued for anything other than to sell. Because if it's discontinued to sell, then we're in the sell unit. If they'd written it that way, the way you're interpreting it, what's the point of the first prong? Why wouldn't everybody do what they're trying to do?
Well, they might be different if it weren't this kind of a park.
And the Attorney General agrees with my interpretation, right? The Attorney General agrees with my interpretation, right?
Attorney General does, but in my opposition or my response to the
Yep,
amicus
I
brief,
read that, yep.
I put in a reference to a case in which they say, if your discontinuance is premised upon a sale, okay, I think that the SJC was discussing the order that is permissible. They say if you're doing a discontinuance, but your premise is you want to sell the property, okay, that's exactly what my clients wanted to do.
Right, okay, but let me ask you as a practical matter. So let's say we do what you want to do, what you want to have happen. They clear it off and they sell it to a developer who's going to be making whatever use somebody would use oceanfront property for these days. I don't know. And you, I assume, agree that you still have to give the tenants who have now been cleared off the land, along with their clutter, the right of first refusal, right?
Yes.
Okay. And is
When you have a buyer, yes.
Right. And is that, when you have a buyer, is that, based on your economic modeling, going to be a higher price or a lower price than if they do it the way the statute suggests?
The way the statute
okay, fine.
Says. The way he says.
The way he says, sure.
I would expect it to be a higher price.
Okay, so less realistic that than the families are going to be able to preserve their campers. I mean, on that spot.
I do need to address the implication that comes with their brief and the amicus brief. We are adversary parties here. We don't work for the campers. The campers have an interest. They're entitled to get what the statute provides or what the
I get it. I'm not,
requires.
right.
But
The statute wants to avoid the problem I'm articulating. Do you disagree with that? Do you disagree that the statute is designed to address the specific problem I'm raising here?
I don't know what the statute was designed to do, but I know that we don't have an obligation to maximize the effectiveness of their ROFRR. The ROFR arises when we get ready to sell. We're not trying to work for them. We're trying to work for us. As long as we follow.
I'm not. Nobody's suggesting this is a false argument. I'm not suggesting that you have a duty, any kind of duty, to work for the tenants to get a price that they like, other than your duty is to comply with the statute, right? And the statute seems clearly to intend that to preserve the mobile home existence of people who live in mobile homes. Right. So, in other words, what I'm struggling with is if the statute is trying to keep these people, give these people the best chance to stay in those homes on that location, we have to interpret this question that has been presented in a way that gives them the best chance. What's wrong with that argument?
If they were homes, I would agree. And this is where, even though the statute applies to my clients, you have to understand the reality on the ground. And these people are not necessarily poor people.
That doesn't matter. That doesn't matter. Let's assume for the sake of argument that the court believes that doesn't matter. Let's assume for the sake of argument that the statute is clearly applies to these people who will use it from May 1st to September 30th. The facts on the ground, what other facts on the ground are you pointing to?
Facts on the ground are that they all have other homes.
Okay.
And
Right, but the statute it's already been decided that the statute applies to these people who have other homes.
Okay, they will get an ROFR. The ROFR may not allow them what they really want, which is to be there with the same properties
the
that
question
they
is what
have.
the statute wants them to have, not what the ROFR wants them. What does the statute require?
The statute requires that they be given an opportunity to buy when we want to sell it. That's what it requires. It doesn't require that they have exactly the same pieces of camper that they have now, that they have as a group, because they have more than 51% of the owners there. They are required to get the opportunity to match an offer. That's
do you agree,
what it requires.
Do you agree that at the 10,000-foot level, the purpose of the statute, the most general purpose of the statute, is to protect mobile home owners?
That's what it says.
Yep. I mean, this is important. Like, that's what it says. That's what it means.
Okay.
No, what do you mean? Okay.
Yes. Yes.
I mean,
It
you
is
have
to
to,
protect
this is actually important. Like, this is the law. And we pass these laws for important reasons. These people, this population, now this may be not the best case to come forward, but generally, mobile homeowners are a vulnerable population. Do you agree?
Yeah.
Okay.
Generally, mobile homeowners, yes.
Because they own their home, and then but they don't own the pad underneath it, and so it can be taken away from them. It's really simple. That's why they're vulnerable, right? That their home, the place their home is, can be taken out from under them. And a lot of these homes can't be moved, so that's really bad. That's why this statute exists. I mean, this population is a little different. I'll give you that, but the principle is really important, right?
Yes.
Okay, and so the purpose of this statute is to protect that vulnerable population, right? Okay, well, okay. So I'm struggling to understand how your interpretation protects that there's sell and then there's discontinue to sell. And we know that sell gives you price X and discontinue to sell gets you higher than X. How your interpretation of the statute is consistent with what you just conceded is the main important purpose of the statute.
The case that I cited in response to the amicus
Right, what
brief,
case?
also, that's somebody against the Rent Control Board. Quinn v. Rent Control Board.
Right.
45 Mass Appeals Court 357.
In Quinn, did the tenants, it's a high-rise rental unit, I remember, right, and the tenants won, by the way, in Quinn, against the Rent Control Board of Peabody, did the tenants have to move out before they were given their right of first refusal?
I don't think that's covered in the decision.
Okay, all right.
But the decision does suggest that if they see that what's going on is the owner wants to sell and then, to discontinue and then sell, they can get together and seek an order giving them the ROFR. The case says, okay, if you don't like the way it's going in terms of the order, have reference to Section R of Chapter 140 and put together your own ROFR. Go to the court and say, we want to have an opportunity to buy this before they finish their discontinuance.
Okay, right. It sounds like what you just said, and this could be true. The case doesn't address the crucial question that we're wrestling with right now, which is the sequence. I think there's no disagreement that they have a right of first refusal, the tenants here, the mobile home owners. The question is whether they have that, they can require your clients to get an offer before they move. And you're saying that Quinn doesn't answer that question.
Quinn says that they could do the discontinuance before. If they're anticipating a sale, they could discontinue in anticipation of a sale. But then they say there's a possible remedy that the tenants could get together and force the issue early before there's an offer and say, no, we want our right of first refusal. They didn't do that in this case. They waited a year and a half, and then they sent a demand letter under 93, and then they started this litigation, which we're in. I think that they and the Attorney General have decided to insert a priority because of what I started my argument by saying. They think that in this respect, it's not just, we don't work for the tenants. We don't have to maximize their result. They will get an ROFR. The judge was convinced of that. My clients testified to it. They will get their ROFR. What value the ROFR has, I can't tell you, because they haven't sold the property yet. But the client, my client, doesn't have to give...
Isn't that contrary to, and it may or may not be what Judge Wood is trying to get at, but let me ask you this. So is it your position that the tenants can be forced to vacate, my words, even before they have a buyer?
Yes.
Then they can get a buyer.
Yes.
And then they can go to those tenants who've now been forced to vacate and relocate and gone through the expense of doing all that to say, hey, here's our buyer, you want to match that? And if so, you can guys all move your stuff back on. Is that what you're saying?
Yes. Yes, they could. Now, in the facts on the ground in this case, which we don't spend a whole lot of time talking about, are that many, many of these units that are there are not mobile homes.
I understand. But the statute is designed to, I think, insulate or minimize the expense that these folks, mobile homeowners, to have them pay to the expense to vacate only to get the right of first refusal and then pay to come back onto the property seems to undercut the statute.
I understand that that's the way the client prologue or the beginning, the statute, that's the way it reads. But I still stick with my client is obliged to do what the statute requires them to do, and that is to provide both opportunities. And it doesn't say in the statute, you have to do this first. I understand the AG would like that to be the case, but it doesn't say that in the statute.
Why is that a good thing for the tenants? I mean, do you concede that your proposal is a bad thing for the tenants? I'm sorry to put it in such simple, blunt, non-legal terms, but if the statute's designed to protect mobile home owners, and your proposal, we can all agree, is bad for mobile homeowners, then it seems like a problem. But maybe you're saying, no, we don't know if it's a good or bad thing for mobile homeowners. It seems to me completely obvious that your proposal is a bad thing for the mobile homeowners, because the price will go up, and they have to move their houses in the meantime.
If they can even be moved. Many of them are not even
right. So they may lose their houses in the meantime.
Well,
right. So it's even worse. Thank you for that. Yes. So in other words, they may the process of removing the clutter might destroy their homes, and then they might have to come, if they're going to come back, they might have to come back and buy a new home. How is that good? How is any of that good for the tenants?
I guess my response would be that when we started this whole thing in 1988, my clients got a very bad deal for them, which was a forever agreement, which says you will be imprisoned by your tenants forever.
We're not allowed to speculate on what motivated that particular agreement one way or the other. All we have is the dispute in front of us. And it seems that we're not allowed to consider whether that was a bad deal and whether they've been good or bad landlords for the last 30 years and maybe the time before that. That seems irrelevant. The question is, how do they get out of this? They seem to want to get out of it. How do they get out of it consistent with the statute, right? That's what we're talking about. What's consistent? What's an exit strategy consistent with the statute?
And I would say, even if it's a bad deal for the tenants at this point, it is an out which is provided for by the statute. And whether that doesn't feel good and whether it's what the tenants hoped for, when they got their notices, they got all this information and they didn't like the information because they said they might have to leave. Well, if that's what the outcome can be pursuant to the statute, then
why should that be the outcome? The Attorney General says
why do I have a duty to make it nicer for them if the statute says I don't have to make it nicer?
Well, right, okay, I got your argument.
So you say simply statutory interpretation. That's what this case boils down to at bottom.
You may not like the outcome, but I think that's what the statute provides.
See, that's your time.
Thank you.
Thank you. Court's in recess. Thank you to all.
meet again, who knows? Whether we meet for a 15th time down the road. I didn't even use my argument. I didn't tell them that the chat